Check, check, check. Check 1, 2.
Good morning, everyone. Like to call to order the Judiciary Committee public hearing for March 4th, 2024. We have a number of bills on our agenda today. This is our first public hearing of the session. Get that fixed. All right, this is our first public hearing on bills for the session. So welcome, everybody. Let me review the ground rules real quick. As is often the case, we have an extensive list and we have a number of bills. So when you come up to testify, please identify at the outset which bill you were testifying on. Please provide the bill number. Don't assume we know. Also, folks have 3 minutes. It is a strict 3 minutes. If you've submitted written testimony, please do not read it to us. We have it. It's in writing. We don't need you to read it to us. You can refer to the fact you've submitted testimony and you can summarize. And then we will allow questions from the members. I would ask the members again, these are public hearings. These are opportunities for the public to speak to us. This is not the time to engage in debate on the bills. If you know the answer to the question, don't ask it. This is not trial. This is not a courtroom. And we will proceed through the list. And there is no swapping. No. We go in the order that folks have received a number on. All right. With that, first up, I have Brian Corton. Brian Corton with us?
Yeah, I'm here.
Go ahead, sir.
Good morning, Senator Winfield, Representative Staffrom, and distinguished members of the Judiciary Committee. My name is Brian Corton. I am speaking to you as owner of Water's Edge Family Campground, a privately owned small business in Lebanon, Connecticut, and as a volunteer chairman of the board of Connecticut Campground Owners Association. I am speaking in support of HB 5256, an act concerning liability for injuries inherent in camping while at a private campground. As I'm sure you're aware, you have received a number of letters testifying in support of this legislation from Connecticut Campgrounds, as well as the Regional Industry Association. With help and input from the Connecticut Trial Lawyers Association, we have developed language that we feel takes into account the needs and considerations of both campers and campgrounds in the event of an injury. It recognizes that there are inherent risks in the camping experience, in addition to acknowledging the need for providing as safe an environment as possible. Without question, every one of our member campgrounds works to provide a safe and enjoyable outdoor experience for their visitors. Without doubt, that is their responsibility and desire. This legislation attempts to acknowledge the responsibilities of both the camper and the campground in providing a safe and enjoyable camping experience. There are precedents regarding inherent risk in place in Connecticut with statutes for the ski industry, section 29-212, as well as the equestrian industry, section 59-557P. In a similar manner, we feel this legislation helps to provide fair and equitable treatment of both campers and campgrounds in the event of an injury. The 48 campgrounds of the Connecticut Campground Owners Association are a significant economic contributor in Connecticut, with almost $250 million of expenditures annually. Almost 1,000 direct jobs and 36.1 million in annual direct wages are a direct result of these small businesses. We clearly want to provide an environment where this element of our economy can grow and prosper while providing a wonderful outdoor experience for our visitors. We hope you share the same goal. We look forward to your support and thank you for all your hard work on behalf of the citizens and small businesses in Connecticut.
Thank you, sir. Questions from the committee. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, sir. Can you hear me okay?
As limited as my speakers are, yeah, I think I can, yep.
Okay, I'll try and speak up. Is that a little bit better?
Yep.
Okay, so I'm trying to figure out the distinction between inherent risks of camping and acts or omissions that constitute negligence, which looking at, I'm comparing lines 13, 14 with line 17 through 18. It's an exemption from this exception that if the campground commits an act or omission that constitutes negligence, so at some point somebody's got to determine whether or not it's inherent to camping or negligence. You would agree with me there?
Yes.
Okay, so let's just say, for example, that there's a bee's nest at the campsite and campers, maybe some workers have been stung by bees, and then somebody comes there and camps and their kid gets stung by a bee and dies because they're allergic.
Okay.
Would there be exemption for suit in that particular case?
Well, we feel that each case should be determined on a case-by-case basis. That is specifically why the language was left, I'm not going to call it vague, but as vague as it is, just because there are so many different, scenarios that could come up. Each case would have to be determined, on an individual basis.
Okay, understood. I just, a claim like that probably would put through with an insurance company. They would say, we got this statute in Connecticut, and that's an inherent risk of camping because it's nature, right?
Right.
Similarly, another fact pattern, that there's a group at the campground that traditionally gets drunk, rowdy, causes disturbances. And it's gone on a few times, and now it happens again, and there's a fight and somebody gets injured. Am I to expect that that's not inherent to camping?
Correct. That would be on the campground management for not handling that.
Okay, well, I thank you, and I thank you for the exchange. Thank you, Mr. Chairman.
Representative Drabitsky.
Thank you, Mr. Chairman, and thank you for coming in. Can you hear me okay?
Yes.
Okay. I wanted to kind of expound on Representative Fishbein's questioning. As somebody who practices in the equine industry,
Okay.
and I'm very familiar with the equine portion of that, which was developed based on the ski resort portion that you were discussing.
Right.
So the question becomes, how much can a campground rely on a bill like this if it's essentially got an exception in it that swallows the rule. The exception being, except if there's negligence involved. I know that that very issue comes up in the ski context and in the equine context. Are you confident that the language that sort of mimics those two contexts is going to do your members any good?
Well, we're hoping it would. We're feeling that this is a start anyway.
Okay. All right. Well, I appreciate your coming in to discuss it. I would just caution against putting too much reliance on a statute that has a big gaping hole in the middle of it. Perhaps at some point in all of the context that there could be a way to resolve that, but short of adopting an assumption of the risk standard on all issues in Connecticut, I'm not sure how that would be done. But do you have any comment on that?
Not specifically, no.
Okay. All right. Well, thank you very much. I appreciate your coming in. And thank you, Mr. Chairman.
Thank you for the question.
Further questions or comments? Further questions or comments? Seeing none. Thanks for being with us, sir.
Thank you.
Next up will be Marissa Dungy.
Good morning, Senator Winfield, Senator Kissel, Representative Staffstrom, and Representative Fishbein, and members of the Judiciary Committee. Thank you for the opportunity to speak this morning. I'm speaking in support of SB number 272, an act concerning adoption of the Connecticut Uniform Trust Decanting Act. My name is Marissa Dungy. I'm a member of the Executive Committee of the Connecticut Bar Association's Estates and Probate Section. I was also the person who chaired the committee that considered this legislation. I won't assume that you know what trust decanting is, so I will start from the beginning. It's the term used to describe a distribution by a trustee of one trust into another trust for the benefit of one or more of the beneficiaries of the first trust. It has its origins in common law. It's the kind of idea that if you can make a distribution to an individual, you can make that a distribution in trust subject to terms and conditions that are not set out in the original trust document. And so in Connecticut, we have support for it already in existing law, that support for the common law. There's a provision in the Power of Attorney Act that specifically talks about the ability of a person with a power of appointment in a fiduciary capacity to appoint assets in further trust. And so this legislation does not bring trust decanting to Connecticut. Instead, it provides procedures and safeguards to the act of decanting that Connecticut does not currently have. At the time, as of today, 38 states have trust decanting statutes, and at least 3 others and the District of Columbia have introduced versions of the Uniform Trust Decanting Act. It has become increasingly the preferred method for decanting by fiduciaries and practitioners because of the protections that statutory decanting provides. Among these and the procedures, just setting forth, who's entitled to information, what information must be conveyed, a default notice period, when and how to involve local courts, as well as safeguards, making sure that a trustee is not personally benefiting from a trust decanting, or unintended consequences that, if your trust qualified for a marital deduction initially, that you can't make changes that would affect the tax status of the initial trust. So you kind of preserving what was there and not kind of inadvertently messing it up in the course of decanting. And so these safeguards are important protections that make statutory trust decanting the preferred method. Because Connecticut does not have a statute. As I mentioned, 38 states have them, including a handful that are considering the legislation. It's incredibly easy to simply move your trust out of the state of Connecticut in order to take advantage of this type of statute. We, in creating the Connecticut version of it, did look to, we spoke to the probate court administrator's office and incorporated detailed comments from them. We considered the attorney general in there, and are comfortable that it covers the charitable interest to the degree they would want it to, as well as putting in a provision that they'd requested for the Uniform Trust Code on Medicaid payback trusts. And so I feel like this component is important. The modernization of Connecticut trust law with the Uniform Trust Code has been incredibly effective in creating trusts here, and I think this will be an important part of keeping existing trusts here. So I hope that you can support me in this.
Okay, thank you very much. Any questions from the committee? Senator Kissel.
Thank you very much, Chairman Quinn. Thank you so much for coming to testify. I'm glad that you, in your testimony, indicated that you sort of brought together sort of best practices for a variety of the other jurisdictions, as well as the input from folks within our state. It sounds to me like this is just a good business bill for practitioners. Right now, it appears that since we don't have anything on in statute, that folks might feel more comfortable going out of state to have this take place for the reassurance of a statutory framework. So I look at it as good for the bar. My question regarding this is, how would this sort of come to pass? Who would like decide it's time to decant the elements of this trust into the elements of a second trust?
Oh, it's an action that the fiduciary would take. I mean, typically anytime a fiduciary is acting, they may be, taking kind of input from beneficiaries or other, interested parties, somebody who created the trust, advisors and whatnot. As there some sort of aspect of it is said, sometimes it's just modernizing the trust, right? We have the Uniform Trust Code, a lot of aspects of it, or the Connecticut Uniform Trust Code, a lot of aspects of it are available to trusts today, but the trust isn't necessarily drafted with that, or they don't have fiduciary succession that's kind of, accounted for today's circumstances. And so basically it's prompted by some, deficiency in the existing trust document that doesn't really work, or it's a beneficiary for whom it would make sense to keep assets in trust, but it's meant to distribute out at a certain age. And so it's just whatever was considered at the time it was created is no longer kind of in the best interest of the beneficiary because of either developments in the law or just the circumstances at the time that make decanting, often a good option. And it's typically done if the trustee has broad discretion. It's typically done without court involvement. And so as I said, there's notice to the parties, so people are aware of it, but it's just some deficiency in the trust document, usually in the circumstances not, as said, developments in the law or circumstances not anticipated at the time the trust was created.
Well, as much as we always try to look into the future and anticipate what may or may not occur, everything moves so fast. You know what? I sort of think that was the same case 100 years ago. It's just wherever you happen to be in time, it seems like things are just moving so quickly. But I appreciate your outreach to me prior to this hearing this morning, and explaining this. And I certainly will be supporting this as it moves forward. Thank you, Mr. Chair.
Thank you.
Representative Fishman.
Thank you, Mr. Chairman. Good morning. Is it possible to decant a trust in Connecticut today?
Yes.
Okay. And under the present law, who makes that decision?
It's still a trustee decision. It's as said, it has its roots in common law. And so the idea that a trustee has discretion to make a distribution to or for the benefit of a beneficiary, that the trustee could make that distribution in trust for the benefit of the beneficiary.
So just, about 5 years ago, I had a case that it was hundreds of millions of dollars. There were a series of trusts irrevocable to lineal descendants of the establisher. And in that case, evidently, Yale Law School uses the testamentary documents of this individual as the example of the worst ever drafted. And in that particular case, it was actually the probate court that created these series of very complicated trusts and appointed the trustees who actually wrote the probate practice book to oversee this situation. And in those cases, the beneficiaries wanted to change the terms of the trust, but the trustees objected. Does this change any of that?
No, I would say that a probate court is always involved if it's a testamentary trust, so created by the will of an individual, or if the probate court is simply solicited, they're petitioned for their input on it. But an inter vivos trust wouldn't need to go to a probate court for it, but it's always the trustee's actions. There are some examples under like, for example, the Connecticut Uniform Trust Code on trust modification that does involve the beneficiaries and the trustees, mutually agreeing to it, or a beneficiary an opportunity to petition a court to do something. But this is very much a trustee, decanting this is a trustee action. It's a distribution from the trust. It's just that instead of going outright, it goes for the benefit of the beneficiary in a further trust document. Beneficiary consent is not required. Just like any other trustee action, they could, raise an objection and they are given the information here in order to do that. But it's not something that the beneficiaries have to consent to or could, initiate. You can't force a trustee to decant a trust.
So the proceedings, I think I saw something when you said, doesn't have to deal with the probate court, right? So how does this look? Somebody is a irrevocable trust, the creator has now passed, we have beneficiaries that are relying upon perhaps income, and the trustee all of a sudden one day says, I want to change those terms. What is the notice to these individuals?
So there's already notice provisions for a trust under the Connecticut Uniform Trust Code. And so these aren't necessarily all that different, but this more provides what needs to be noticed, and it provides for advance notice. And what they would get would be a copy of the old cold trust agreement, a copy of the new trust agreement, as well as the kind of resolution of an intention to decant. There are certain protections in here. I said what a trustee can't do, and you can't take away a mandatory income interest. And so they are limited. You can't add beneficiaries through a trust decanting. You can only do what you were allowed to do, and then kind of a smaller subset of that. So if you had 4 beneficiaries and you wanted to decant into 4 trusts, 1 for each, in theory, you could do that, but you can't introduce a new beneficiary or take away something that's vested, like a mandatory income interest. Even if for example, if you could make distributions for health, education, support, and maintenance, a lot of trusts use that standard. The succeeding trust would have to maintain the same standard that the original trust had.
Now, this is titled as a uniform act.
Yes.
Am I to understand that other states have adopted the language that's presently before us, or is this a Connecticut model?
All uniform acts are adapted somewhat to the state that they're in, but the Uniform Law Commission did approve this act, the basis of what ours is, in 2017. 23 of the states had statutes that predated the Uniform Act. And so since then, 15 have adopted the Uniform Act or substantially similar. Our draft has been provided to the ULC, who has confirmed that they agree that it is still a Uniform Act. We made changes, as I mentioned. We added that Medicaid payback provision that the Attorney General's office had requested in the Uniform Trust Code. We did adapt the provisions. New York has had a decanting statute since 1992. And it was a little bit different in certain aspects than the Uniform Act. And so we did make a couple of changes because we have a neighboring statute that people are familiar with that had some beneficial language, we felt. But it is still a Uniform Act, as the Uniform Law Commission still considers this a Uniform Act in its consistency with the Uniform Act.
So Judge Kefala Streeter in her written testimony has asked us to permit decanting to have a fee. And
yeah, thank you, Representative Fishbein, for mentioning that. I did read her written testimony. We worked closely with the Probate Court Administrator's office in addressing any kind of concerns they had around the language, and had added a provision to the statute on jurisdiction. So it'd be clear kind of who had jurisdiction over this as a type of petition. I saw that she also requested that 45A-106A be amended to specifically include this as a petition for which a probate fee would be paid. I would say that we had assumed that it would be paid. That 106A is a pretty broad statute, but I appreciate that it does specifically mention certain types of petitions, and have no qualms with adding it. If it had been an item we discussed, I would have inserted it directly.
so that sort of brings me to where I started. In your experience, a decanting action before the probate court doesn't incur a fee presently?
I think basically any petition to the probate court currently incurs a fee. And so, I mean, it's a $250 fee. I think that that's the norm. I have not had occasion to do a decanting in a probate court, but my partner has, and I know that they had done it with a petition and a fee. And so that is our expectation of how it would be handled by the probate court.
Yeah, so I was a little, taken aback, because if it presently exists, but we've got the probate court administrator saying there's no authority to charge a fee, and I'm trying to put the two together.
Yeah, so it made sense. It presently exists as a common law. So if you have a trust where the trustee has, discretion to make a distribution to or for the benefit of a beneficiary, the distribution could be made in trust. And so trustees are undertaking them with, simply with the advice of counsel, but not necessarily in a probate court. They could do it without a probate court, just part of the discretion that they have under the trust agreement. If you have to go to court, instead, my partner has done a petition in probate court for a testamentary trust. And he, did file a petition, the court approved it, and a fee was paid. So it, it kind of went as it would go, because you could do the decanting. It's just that if you're in a testamentary trust, everything requires court approval. So I know for a fact that at least that one was approved in, kind of the ordinary course of procedure, but there isn't a set procedure for how, what's required. And so, we have 54 probate courts, and each one, has to operate on their own. So this is why we work closely with the probate court administrators, because this procedure also helps our probate courts in terms of having a set procedure for how to address these types of petitions and what should be done, so that you don't have 54 different results.
No, I appreciate that. And thank you. Thank you, Mr. Chairman.
Thank you, Representative Fishbein.
Further questions or comments? If not, let's get the probate court administrator up here, Judge Beverly Street Capelas.
Good morning, I'm Beverly Strike Cafalas, Probate Court Administrator. I'm assuming there are many members on Zoom. So good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. I am here to testify on Senate Bill 272, an act concerning the adoption of the Connecticut Uniform Trust Decanting Act. I have submitted written testimony. We did work with the Bar Association. I have no issues with the legislation. My specific reference to 45A-106A is that although in certain circumstances, modifying or terminating a trust is already provided for under the Uniform Trust Code, and other decanting that occurs in Connecticut under common law does not come before the probate court. 45A-106A, which is our fee statute, does not expressly list the provisions under which the probate court would have jurisdiction here under Section 9. And to make sure that the filing fee provisions are consistent with this act, I would ask that it be explicitly listed. There are only certain circumstances when the probate court would be engaged in trust decanting, and that is specifically set forth in Section 9. Some of the language in Section 9, we do have fee statutes for example, a fiduciary seeking instruction from the probate court, but there are other additional provisions related specifically to this act under decanting that are not spelled out in our bill statute. We do appreciate the Bar Association did recognize a number of our requests. I thought, frankly, that the provision about the fee had been raised, and perhaps it was an oversight that it wasn't expressly included. I would be happy to answer any questions you have.
Any questions? If not, thanks for being with us.
Thank you.
Marissa Belair.
Good morning, Chairman Winfield, Chairman Staffstrom, Ranking Member Kissel, and Ranking Member Fishbein, and other distinguished members of the Judiciary Committee. My name is Marisa Belair, and I'm the current president of the Connecticut Trial Lawyers Association, or CTLA. I'm also a practicing attorney at the law firm of Lynch, Traub, Keefe, and Arante in New Haven. I'm here today to voice CTLA's strong support for two bills. The first is House Bill 5257, an act concerning liability for damage to person or property caused by a dog. and House Bill 5325, an act concerning payments and benefits to individuals with partial permanent disabilities. I'm also here to voice opposition to Senate Bill 213, an act concerning the reduction of economic damages in a personal injury or wrongful death action for collateral source payments made on behalf of a claimant. Now, you'll be hearing in greater detail from my fellow CTLA members who are signed up to testify today. Each of those has substantive knowledge about each of the bills that are presently before this committee. That being said, I'd be happy to try to answer any questions the committee may have for me.
Questions from committee? Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Belair, it's great to see you again twice in a week. Can you just explain in a little detail the opposition of the trial lawyers to the bill that you came and testify in opposition to?
Yeah, sure. So your Senator Kissel, I think what you're referring to is Senate Bill 213. And my colleague Mike D'Amico is here to talk more substantively about that bill. But generally speaking, it really just relates to the substantive problems that we anticipate that bill may create. And Mike can speak more in detail to that if that's acceptable.
Sure. And my other follow-up to that is on the dog bite issue. Some people have said that they feel like it's almost double dipping, or you want it all ways. And why is the bill before us worthy of adoption and passage? And how is it just as opposed to what detractors have classified it as?
So once again, I'll refer to my colleague Kathleen Nastri, who'll be up momentarily, but we do not feel as an organization that it is double dipping. Essentially, the language that we are saying should be included really just is consistent with other parts of the statute. The best example I can give you is that if there is a dog walker that is charged with walking a dog and that dog is owned by someone separate, it should be no different for that dog if it should cause harm by biting someone, for the keeper of that dog to be obligated to pay damages for that dog bite, as would the owner.
And typically with the dog bite matter, isn't that usually covered by someone's homeowner's insurance?
Typically.
Okay. Well, it's always great to see you. Appreciate the efforts of the trial lawyers and making sure that we have a fair and just society, and look forward to the testimony that's going to be forthcoming. Thank you very much, Chairman Stafford.
Thank you, Senator Kissel.
Further questions or comments for this witness? If not, thanks, Ms.
Thank you.
Brooke Foley.
Good morning. My name is Brooke Foley. Good morning, chairpersons, ranking members, and distinguished members of the committee. I'm Brooke Foley. I'm from the Insurance Association of Connecticut. I am here to express our support for Senate Bill 213 about wrongful death action for collateral source payments. And House Bill, we are here in opposition of House Bill 5325, an act concerning payments and benefits to individuals with permanent partial disabilities under workers' compensation. I will do as you asked and not read my testimony, but basically we are here because workers' compensation benefits in Connecticut are already very generous, and this bill would increase the rates for workers' compensation for employers, and it would also increase costs to employers. Under Section 1 of 5325, it would increase the rating for the cervical spine injuries. Section 2 would give the administrative law judge discretion to double the 308A benefits. And Section 3 would give a surcharge to workers who are going through the program at the Department of Aging for voc rehab. And all of these would increase costs for employers and increase workers' compensation rates. I would also ask you to support Senate Bill 213. And this bill, right now, the language of the statute prohibits any consideration of any right of subrogation in a wrongful death or injury cases. We are asking that you please amend the statute to correct that language so that it will allow plaintiffs to be fairly compensated for their economic loss. Thank you.
Representative Quinn?
Thank you. And good morning, Brooke. Nice to see you as always.
You as well.
Dealing with 5325, has the Insurance Association done any analysis as to exactly how much they think rates would go up if this were to pass?
I have spoken with the representative of NCCI, and he has given the indication that it is very difficult to assess the exact rates increase with the language that this bill has right now. For example, where it talks about the, in section 3, it talks about a surcharge on the employers for to give them, sorry. To give them a pay during the program. It just says to give them that pay. It doesn't say how exactly that would be paid for or how much it would cost or anything like that. So with the language of the bill right now, it's not possible for us to give you an exact assessment of what the rate increase is going to be.
Okay, so it's possible that there may not be any rate change because of these provisions.
Well, the way the bill is drafted right now, it says within existing appropriations, but the way that the Workers' Comp Commission, the way the program in the Department of Aging for voc rehab is funded is through the Workers' Compensation Commission. And the Workers' Compensation Commission is funded by a surcharge that is added to the workers' compensation insurance every month for all employers. So employers are paying for this program, and it's collected by insurance companies and they pay it to the state on behalf of employers, but the employers are paying for it. So all of those costs will go up.
Okay. But it's also possible too that if we have more people taking advantage of vocational rehabilitation training and thus getting training in other areas, that they're, at least in terms of the additional 308A benefits, while it would be an option to collect them, it's also possible that they may not need to if we're doing a better job of getting people back to work who have permanent impairments.
If people go back to work because they have a permanent impairment and they're able to get back to work, then that's the ultimate goal, right? Is to get them back to work. But the way that this bill is drafted right now, it makes them eligible for the administrative law judge to consider doubling the 308A benefits just for filling out the paperwork and meeting with the counselor. They don't have to actually go through the program to be eligible for this benefit. So that by itself is going to increase the rates.
Okay. All right. Thank you.
Thank you.
Further questions or comments? Further questions or comments? Seeing none. Thanks for being with us.
Thank you.
Mike D'Amico.
Good morning.
The Groundhog Day, Mike.
Co-chair Representative Staffstrom, Vice Chair Mike Quinn, Ranking Member Senator Kissel, and Representative Fishbein, and all the members of the committee. Good to see everyone this morning. My name is Mike D'Amico. I've been a trial lawyer for over 38 years, representing folks that have been injured through the carelessness of others. I'm a past president of the Connecticut Trial Lawyers Association, current co-chair of the General Tort Committee, along with my colleague Marissa Belair, who you heard from a few moments ago. I was trial counsel. My firm was trial counsel in the case of Marciano versus Jimenez. That was the Connecticut Supreme Court case that dealt with the collateral source rule, and it went up in 2016. I'm here to speak in opposition to the changes that are being made to the collateral source statute. That's Senate Bill 00213, which in essence seeks to overrule that decision, which frankly changed nothing. But it would make a dramatic change to the tort reform legislation that was passed back in 1986 and 1987. I submitted written testimony. I'm not going to belabor that, but in summary, the collateral source rule prevents careless people and corporations from benefiting primarily from medical insurance as well as government-provided benefits, and instead is intended to deter careless conduct. It was weakened in the 1986 tort reform through a lengthy and complex series of negotiations between lawyers representing people injured by careless conduct, defense lawyers defending careless people, the insurance industry, and business advocates. And that lengthy process gave careless wrongdoers a limited benefit for medical insurance that the people they injured had paid for or earned. A reduction, in essence, for medical bills paid by insurance, less the premium amount that had been paid by the injured person. The task of trying to calculate cost to provide benefits to injured people for plans, be they privately self-funded or publicly funded by government, is complicated if it can actually be done at all, and would financially burden private employers and government agencies with this task on a regular and a frequent basis. So I would urge you that the compromises that were struck back in 86 and 87 should not be upended with this bill. And I'm happy to do my best to answer any questions you may have about that in particular.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney D'Amico, it's great to see you as always. So, I do not delve in this area often, and to me, it's a little bit of gobbledygook, and it shouldn't be. So if you could just give me like the really basic version of what is taking place here, what is going on in the proposed bill, and what do you oppose?
So it used to be back historically that folks who did wrong to someone and injured them were not allowed to benefit from the collateral sources that they may have purchased or earned through their employment that may have led to payment of their medical bills. And the idea behind it is we want the wrongdoer to pay for what they had done, to be accountable. And so the purpose of tort law is to deter that type of wrongful conduct. So what happened with tort reform is that collateral source rule was limited in its application, so that the way things are right now, if there's medical insurance that pays bills, then the deduction is made for the amount that the medical insurance paid towards those bills, less the premium amounts. So as an easy example, if somebody had $10,000 in medical bills, $8,000 was paid by medical insurance, and there was $2,000 of premiums, there would be a $6,000 reduction from that. So instead of getting 10, they would get 4. That's the way it works currently. And what this bill is asking to do is to allow for a further reduction from the medical bills for even plans that have a right of subrogation or a lien. When the compromise was struck back in 86 and 87, the statute was clear. You do not get any reduction for a right of subrogation, a medical plan that has a right of subrogation or a lien. And the reason for that is because it has to be paid back. And so what this bill is saying, well, we understand that some of it has to be paid back, but we want to get a reduction for everything else that didn't have to be paid back. The problem with that is it's not an easy calculation to make, and I'll explain what happened in the Marciano case. The gentleman was a UPS employee. UPS has a self-funded plan. In order to calculate the costs that would have provided that benefit to Mr. Marciano, the company has to go back and calculate all of the contributions that they made to their self-funded plan, in addition to the contributions that Mr. Marciano had made. When you're dealing with government benefits, it's even more complicated. I mean, I'm not even sure how it could be done, because we as taxpayers make contributions to those plans, in addition to contributions we make from pay deductions and things of this nature, whether it's Social Security deductions and whatnot. So how we would ever calculate that cost in order to make some fair reduction to get some net collateral source offset would be, I'm not even sure how it could be done, not to mention the fact that employers and government agencies would have to set aside a cadre of people in order to make those types of calculations, because we as lawyers wouldn't be able to do that. We'd have to rely on the government to tell us those costs associated with their plans, and private employers to tell us the costs associated with their plans. Probably result in hearings where we have to subpoena that information. I mean, and that was part of the rationale, I assume, for why that was a carve out of the compromise, that, you know, medical insurance premiums that that is a hard and fast number, we can calculate that. But these other costs that are associated with it, how do we calculate those? So, I mean, it's going to place a burden not only on employers, it's going to place a burden on government. It's going to create backlogs in the court hearing process. We're going to have more court hearings than we already have related to these types of collateral source reduction. So it's just a bad idea.
Okay. And Attorney D'Amico, ultimately, if this bill moved forward, who would be the net beneficiary? Would it be the defendants themselves? Would they ultimately have some sort of financial gain, or would it in actuality be the insurance industry that is insuring, I would say 99% of these defendants? Occasionally you get someone that doesn't have insurance coverage regarding some kind of negligent action, but that seems to be few and far between in my life experience. And as much as I said gobbledygook, I did have quite a bit of experience with personal injury matters and brought several cases, none of which ended up, well, we picked a jury, but then we settled. So it just seems to me that the ultimate beneficiary of this bill, should it go forward, is actually the insurance industry, or am I just seeing that incorrectly?
I think it's both. It's not just cases of uninsured where the benefit would go directly to the wrongdoer, but there's excess judgments, you know, that also are the responsibility of the insured. So, and there's also self-insured retentions, and you know, it gets a little bit more complicated. But I would say that you're correct that I would say probably in large part, as cases go, the insurance industry would get the benefit of it, but the deterrence effect of it is intended to be a deterrent effect against the wrongdoer. And oftentimes that's seen by means of uninsured folks, excess judgments, self-insured retentions, and those types of things.
Well, Counselor, I appreciate your testimony. You maintain that thread, that strain of this is unjust, and that the whole tort system is predicated on trying to dissuade individuals from behaving in a negligent or even with malice aforethought, some intentionally wrongdoing. I'll definitely consider your views, but I think you're singing with the angels on this one. Thank you, Chairman Stafford.
Representative Osborne.
Thank you, Mr. Chair. I'm curious, by the way, good morning.
Good
Thank you for being
morning.
here today. I'm curious, so at the time of the original compromise that you talk about, what we really saw was a benefit to the insurance companies that insured the car owners, the wrongdoers, but a detriment to the insurers who are providing the medical insurance because they're stuck with the medical bills that perhaps used to have been covered by the insurance companies covering the cars and the wrongdoers, correct?
I'm not sure that I see that. The medical insurers have been paid a premium based on actuarial analysis, so I'm not sure how. I'm not sure I understand that.
So you're saying that prior to the 1986-87 revisions, the medical providers or the medical insurance companies weren't on the hook for the medical coverage because the car insurance company was covering it. Is that right?
No.
Oh, okay.
No, whenever you're in a car crash, of course, back in the old days, there used to be no fault insurance, and we probably all remember that. That was part of an automobile policy. Typically, that was in some limited amount. It didn't cover most people's medical bills if they had any kind of a significant injury. So what would happen is the medical insurance company that's people have either privately or through their employer would end up paying the medical bills. I mean, they're paid premiums for that. So there's a separate statute in Connecticut that prohibits medical insurance companies from seeking reimbursement. That's an entirely separate statute. So they're not allowed to seek reimbursement or have subrogation rights to an injury claim. There are some exceptions to that for what we call ERISA qualified plans. Those are federal plans as well as some state government plans, Medicare, Medicaid. They're entitled to reimbursement based on different statutory different statutes that aren't at issue here.
So it really matters who hits you or who you get hit by, right? What their insurance plan will
Ye-
cover.
Well, from a liability perspective, it does matter how much liability coverage somebody has, depending upon the seriousness of the injuries. But it also matters how much insurance you have as an individual, if it's uninsured or underinsured. So, yes.
Right. Thank you very much. Thank you, Mr. Chair.
Further questions or comments? Seeing none. Thanks very much.
Okay. Thank you.
Kathleen Nastri.
Good morning. Feels a little bit like trial lawyer reunion up here. My name is Kathleen Nastri. I'm a past president of the Connecticut Trial Lawyers Association, and I'm here to testify this morning regarding Raised Bill 5257, which I think proposes a correction to a statute commonly known as the dog bite statute. I did submit some written testimony, and so I won't, at the chair's request, I will not read through that testimony, just to point out a couple of things. First is the dog bite statute is a strict liability statute. It doesn't require anyone to prove fault on the part of the owner or keeper of a dog. The stated purpose of the statute is to compensate victims of dog bites or dog injuries. The proposed amendment, I believe, accomplishes three goals. First, it makes the statute consistent with other statutes in that chapter of our Connecticut General Statutes, including the statute right before it, which refers to injury by multiple dogs at one time. It also clarifies a really thorny, although maybe it shouldn't be so thorny, but a rather thorny issue among Superior Court judges on what the meaning is of that word "or" in the statute. And it protects the victims, which is the stated purpose of the statute. There are a number of Superior Court cases that have tried to wade into this morass of the "and" versus the "or" in the statute, and there are conflicting decisions. And the end result of those conflicting decisions is it's hard for litigants on either side of the V, that is plaintiffs or defendants, to know what to do when they have a dog bite injury and there are multiple individuals who might be responsible. In other words, either the owner, who is a registered owner of the dog, or the keeper of the dog, which is defined in a variety of cases as someone who has some control or dominion over the dog. And it does make things very complicated. And I can only tell you, I don't typically do this kind of work, but a couple of years ago, I tried one of these cases, and the "or" in the statute prevented the case from settling pretrial because the owner and the keeper could not agree on what the fair contribution of the two of them was. And as a result, the case went to verdict in Torrington and went to post-trial motions on the issue of the word "or." So it's an important correction. I think it's a simple clarification. I think it will resolve a lot of issues that we have pending out there for victims of dog bites. And I'll answer whatever questions you might have.
Senator Kissel.
Thank you, Chairman Staffstrom. Attorney Nastri, great to see you again. Yeah, I actually commend the trial lawyers for sending folks to testify today, because it really makes our job that much easier. And I think that if anything, we need predictability with our statutes. I don't know if you can maybe share some of those decisions that go in different directions, or maybe even the motion that took place up in Torrington. But we hear from folks, our friends over in the judicial branch, that they just are limited as far as resources go, especially when it comes to marshals and support services within the court system. So if we can just, create an environment where folks can come down and perhaps settle matters as opposed to being compelled to bring them to trial, I think that we're all better off in that respect. So I appreciate your testimony. To me, it's not, and again, since I have you here, that criticism from detractors that it's some form of double dipping, what would be your response to that?
Yeah, it has nothing to do with double dipping. It has to do with certainty and predictability in the system. And it's not as if you are going to get the same compensation from both the owner and the keeper, but you are going to get fully compensated when you understand what the relationship is between those two and whether there is availability or ability on either side to pay the judgment or pay the settlement. Has nothing to do with double dipping.
Thank you, Attorney Nastri, and thank you, Chairman Staffstrom.
Thank you, Senator Kissel.
Representative Fishman?
Thank you, Mr. Chairman. So I'm going back in my mind. Did you have a case years ago where it was a postal worker, it was a medical malpractice case, and then it went to UConn Health?
I don't think it was.
Okay, so let's go to
me.
another one. Anesthesia, there was a case where a woman went in for cataract surgery and they put a needle through the eye.
That wasn't mine, but I know the case.
Okay, no, I remember because I clerked a case of yours like 20 years ago.
I've
So
tried a few.
I remember you from way back.
I
way
hope
back
that's,
when.
I hope that's a good thing. I don't.
No,
I hope that's a good thing.
In that, a lot of people don't know about high-low agreements, sort of like gambling in the courtroom. And I think the jury came back at a 0, but you got like 500, so anyway, on a high-low agreement. Anyway, I'm looking at the existing language. And I thought it was interesting that, public policy wise, we find an action by the child that causes injury to a third person is imputed upon the parent. It's interesting. Under lines 17 through 19, it says, if any dog does any damage to either the body or property of another person, the owner or keeper, or if the owner or keeper is a minor, the parent or guardian of the child shall be liable.
Right.
So I think it's an interesting public, when we talk about, kids out there today creating damage and, that we can't hold parents liable for those damages. I just thought it was very interesting.
And I think, if I could just say, it's pretty common in the dog bite realm that a minor would be tasked with the walking the dog or walks dogs for neighbors or whatever it is. And somebody under those circumstances, if something goes, amiss, has to be responsible. And so I think that it again reflects the purpose of this statute, which is to compensate the victim of the dog.
Yeah, so I guess bringing this down, the problem is that if a jury comes back, let's say $20,000 for personal injuries, it's who's going to pay the 20 grand, but the language before us says either one of them.
Right. Well, the language before you says or, and so the argument that's been made, and this is what I faced in my case, was if you settle against, you settle against the keeper of the dog, the owner is going to argue under the current wording of the statute, you settled against the keeper, you're done. Even if you're not fully compensated because the keeper is either not insured or not able to pay a fair settlement, you have chosen under the or definition to go after one of us. You cannot go after both of us. You cannot get compensated by both of us. That's the way they read it now.
So that takes it to my scenario where the other party is unknown at the time of settlement, and the other party is discovered after an agreement has entered. What happens then?
Well, under my version, the way I would have read the or before I got involved in this morass that I ended up trying in Litchfield, I would have said or means both, right? But under the way the statute has been read and interpreted by some superior courts, or means pick one. So if you found a negligent, not a negligent because it's a strict liability statute, but if you found, say, the owner or the keeper after you had settled against the other party, you'd be out of luck.
Oh, I understand that, but John Smith is the keeper of the dog. The individual gets personal injuries from the dog. Insurance, well, we won't even play with insurance. The injured party contacts John Smith. John Smith says, I'll agree to a stipulated judgment for $20,000. Now, at that point, the owner of the dog is not necessarily known.
Right.
What is the imputed liability? Because this says and. Can John Smith, who's the keeper, bring in that owner merely by signing a settlement agreement, a judgment.
I think under the current reading of the statute, it's unclear. Under the current or,
But
in the
under this
statute.
If we were to adopt this language.
Under this
right,
language, I
it
think,
says and.
right,
So
this,
they're both jointly and severally liable, but under my situation, we only have one agreeer, one of those two parties. So my concern,
yeah,
and I just want to like work out of that concern, is now John Smith has agreed to a judgment for $20,000. John Smith is, is judgment proof, whatever, okay? And now the injured party takes that judgment and says, well, the statute says, you're both liable. So I got this judgment. I'm going to collect against you, even though you had no notice of that. How do I get around that?
the answer is I don't know. I mean, I think I have an instinct that tells me that that wouldn't work for a variety of reasons, but I don't know the answer. And I think under the circumstances of these cases, it's very unusual that we don't know who both parties are at some point. So the owners are usually registered, right? Because they have to, register their dogs with the local authorities. And the keepers are the person on the scene. So they're usually also easily identified. So the question isn't usually who are they? The question is which of these two or more should pay and which has the ability to pay. Because what you don't know is who has insurance, who owns a home, who has a job, who can, compensate these people for their injuries. So it's not so much the identity of the owner keeper, it's the financial wherewithal of the owner and the keeper.
So would you be opposed to some language in here that talks about notice? Because I'm concerned that now that unknown person has a judgment lien, let's say, placed on their real property. What happens with that? Because, normally that comes from notice and due process and all that stuff.
So a judgment lien wouldn't result from this. So if the keeper under your scenario, the keeper agrees to a $20,000 judgment on his or her person, maybe their property. But if the owner is no part of that, then there wouldn't be a judgment lien that would attach. Now, maybe the keeper goes after the owner after the fact and says, you need to contribute because we are jointly and severally liable. But there wouldn't be a judgment lien that would attach because they weren't a party to the original agreement.
Well, and that's why, we're having this discussion and I don't think that is your intent.
It is not.
I'm just concerned about this arbitrary, fusing and joining without some portion of notice.
Yeah, the intent of this is not to double dip. It's not trickery. It's
No,
not, it's all purely like upfront. We know what our options are and we can get the compensation that the purpose of the statute sort of states as its goal.
Understood. I mean, I certainly on a bank X or something like that, the court's not going to sign off against somebody who's not a party to the action.
Correct.
I got that, but you don't need a gatekeeper to put a judgment lien on somebody's property. So a little distinction. Anyway.
Okay.
All right, thank you, Mr. Chairman.
Thank you.
Representative Trubisky.
Thank you, Mr. Chairman. And thank you for coming in. The purpose of this statute, in addition to compensating somebody who's been injured, is presumably also to create some deterrence to people to not allow their dogs to injure people. Would you
Yes.
agree with that?
100%, yes.
Okay. And again, following on Representative Fishbine's scenario, I could see a scenario where you've got a 17-year-old kid who's got a dog, brings the dog to a kennel when they go on vacation. The kennel has the dog. The kennel, somebody trips on the dog. Doesn't even bite somebody, but somebody trips on the dog, which would be covered by this. And now the parent is liable for a dog that the parent may not even know existed. I think that would be the purpose of having the or, as opposed to having joint and several liability, because with the or in there, liability would go to somebody who had the ability to deter the injury. Don't you?
I think that's the problem with the or, rather than the solution that the or provides. So under the way the statute currently reads, in your scenario, the victim of the dog trip could sue either the minor's parents, because that's part of the statute, or the kennel, because they were the keeper of the dog at the time. There is nothing that, there's no fault in the statute. You don't have to prove that one person was responsible or wasn't. So even if in your scenario, this 17-year-old gives his dog to a kennel, he goes away, for a week someplace, and someone trips over the dog, the parents, under the current setup of the statute, could still be on the hook, because there's no limit on that or. It doesn't say the person who has primary responsibility or the person who's in charge of the dog at the time or anything else. It just says or, which is part of the problem.
Then doesn't it make more sense to add a fault element to it as opposed to just a joint and several liability for somebody who may not have any ability to prevent the injury?
I don't think so, because unless you want to change the purpose of the statute, the purpose of the statute is to provide compensation for victims of injuries by dogs. And that's why it is a faultless statute. You have to prove who the owner is, who the keeper is, and other, certain other criteria, but you don't have to prove fault. There's no obligation to prove a vicious propensity, or, there's no first bite rule anymore. None of that exists, because the way this statute was written was designed to eliminate that. I do think, though, to your original point, which is the purpose of sort of deterrence, that the statute does that. So, right, so the tort system has three purposes: deterrence, compensation, accountability. And this statute, if you make sure that you can go after either both the owner and or the keeper, accomplishes that, because then people know that there is a consequence to not keeping their dog on a leash, to giving their dog to someone who is irresponsible as a dog walker, to putting it in a kennel where the dog won't be properly cared for. All of those things are accomplished because you have a dog, and dog ownership carries a certain level of responsibility.
What about if the keeper is animal control officer?
I don't, I was actually thinking about that issue earlier, about what happens if the dog is owned by a municipality of the state. I don't know the answer to that, honestly. But I think they are probably not, you know what, I don't want to guess. I don't know the answer to that.
Okay, because under the current statute, if, let's say, an animal control officer has possession of a dog.
Yep.
And the dog bites somebody, the logical person that would have to pay for the injury would be the owner of the dog. But under this, the town would be jointly and severally liable.
So there is a lot of case law on what it means to be the keeper of the dog. And the answer to that question, and I'm happy to look at it and report back to the committee, might be in there, because there are certain limitations of what it means to be the keeper. And if it's a statutory responsibility or municipal duty to be the keeper of the dog, that probably limits the exposure of the municipality. And I'm happy to look at that. I just don't know the answer.
Okay. Now, I know that language similar to this, to the existing statute, is also used in other contexts, such as with regard to horses. Is it your feeling that changing it here will be a precursor to changing it elsewhere in the statutes?
I'm not familiar with the language on horses. If you have it available to, I'm happy to take a look at it. I don't know how this would affect that. I know that this change makes the language in statutes relating to dogs consistent. I don't know about the horses.
Consistent with what?
Consistent with other statutes in the chapter that deals with dogs and dog ownership and liability for injury to dogs. For example, the statute one above this one. So this is 357, I think. 356 talks about liability caused for injuries caused by multiple dogs. And that says the owners and keepers of multiple dogs shall be jointly and severally liable. So it makes it consistent with that. There is a statute on criminal liability. It would make it consistent with that. And so this, I don't know how it affects the horses. It makes it consistent with dogs.
Okay. All right. Well, thank you very much.
Thank you, sir.
Appreciate it. Thank you, Mr. Chairman.
Further questions or comments from the committee? Seeing none, thanks for being with
Thank you,
us.
sir.
Mark Buchanan.
Good morning. I'm Mark Buchanan, and I very much appreciate the opportunity that the committee has given me to speak in opposition to Senate Bill 214 concerning gender-affirming healthcare services. I'm a board-certified internist in Connecticut for the last 30 years. In my retirement, I have dedicated myself to teaching medical ethics to students. This requires that I keep up to date on the very complex issues surrounding gender medicine. I'm very familiar with the standard-setting organizations like WPATH, the American Academy of Pediatrics, the Endocrine Society. I'm also very aware of the systematic reviews being done in several European countries, which were very early on adopting the same kind of gender-affirming care that is written about in this bill and have now become disillusioned with it. The bill appears to not understand that there are ways of treating gender dysphoria other than the gender-affirming approach. The major competitor is called gender exploration therapy, which is nothing but classical psychotherapy applied to people with gender dysphoria. It takes a very comprehensive look at all of the co-occurring conditions which might come along with this, and they are very, very common in our youth who go to gender clinics. Autism, OCD, eating disorders, depression, anxiety. The gender-affirming condition looks at all of this and says, what's important is to fix the gender dysphoria, and we think the rest will take care of itself. Gender exploration says, no, we need to manage all of these things and then see what's left after we've controlled some of them. So it's interesting, the failure to provide that sort of therapy is part of the reason why the world's largest youth gender clinic, Tavistock in the UK, got shut down because they were doing purely affirmation. Now, I have to tell you that I'm not a psychotherapist, and I didn't make this up, but this is now the opinion of several major European countries, which very early on enthusiastically adopted the affirming approach. They now have looked at this again and realized they didn't get what they thought they were going to get, and have looked at the evidence and said, no, we're going for gender exploration therapy. It's also the opinion of world-renowned psychotherapists Laura Edwards-Leeper and Erica Anderson. In 2021, they wrote an editorial in the Washington Post saying, the mental health establishment is failing our trans kids. Gender exploratory therapy is a key step. Why are we not providing it? So with this background, I have to look at Bill 214 and ask, why does it protect only gender-affirming care? Why does it favor one type of treatment over another? Why does it push the kind of treatment that European countries are backing off?
So that's 3 minutes. I have a question for you. Have you read the bill before us? Do you have a copy of the bill? Have you read it?
I do.
Okay. What about existing Connecticut law is changed by this bill?
My understanding is that existing Connecticut law inappropriately conflates gender dysphoria with reproductive rights. Am I correct on
But
that?
what changes? This is the bill before us is a very technical one.
Mhm.
Okay, it is. I just want to be clear. We are not going to debate here today gender affirming care, whether right, wrong, indifferent. That is not the purpose of this hearing. That's not the bill before us. The bill before us is a technical one proposed by our nonpartisan legislative commissioner staff. So the question that we would debate on this bill is, are there any changes to existing Connecticut law? My understanding is there's not. This is a consolidation and a technical fixed bill. If you've got some evidence that that's not the case, I'd like to hear it.
Okay, well, I'm certainly not a legislature watcher, and I could have missed it. My question is, this language that it's in here, was this subject to public debate and commentary at some
That's
prior
not,
time?
look, my question to you is, if you don't know the answer, I'm not trying to put you on the
Mhm.
spot. You don't know, but
Sure.
I'm led to believe that the language before us is simply technical corrections to Connecticut statute. That's one of the things this committee does year in and year out. We have tech revisor, we confirm and adopt the general statutes. It's one of our functions of government, is to clean up where there are ambiguities in statute. My understanding is the bill before us does not change substantive Connecticut law, and I'm asking whether you're aware of any way that this bill changes what is current existing Connecticut law.
Yeah, I am not, and it certainly
Okay.
is not my intention to throw a monkey wrench into the processes of lawmaking. I simply saw something in what is apparently existing statute that appears to be medically incorrect.
Okay, thank you, sir. Further questions or comments from the committee? Representative O'Day?
Thank you very much, Mr. Chair, and thank you, Doctor, for your testimony. And to the good chair's comments, my understanding is that we're basically including the definition of gender affirming healthcare in this tech bill to apply for basically to cover healthcare services that may be performed in Connecticut and illegal, and protecting those who provide those services from liability from out of state. Mr. Chair, if I may, through you, is that what this tech proviso, this bill does?
I'm sorry, Representative O'Day, I was confirmed the ranking member. Could you repeat the question again?
Sure. My understanding is we're adding the definition of gender affirming healthcare services. And essentially that's in lines 14 through 19. And then we're adding that like in line 27, when a person has a judgment entered against them in any state for performing those gender affirming healthcare services that are legal in Connecticut, if they're facing a judgment from out of state, we're providing them the ability to get damages as a result of that judgment from out of state, or essentially providing them with immunity. Am I correct in my reading of this statute?
It's my understanding that that is existing Connecticut law, but I'm going to refer to LCO to confirm that so that we don't go down this rabbit hole if we can avoid it. LCO?
Yes, Representative Stastrom, this bill was intended to consolidate existing statutory provisions from separate bills that passed in 2022 with separate legal protections afforded for different types of services. The protections are identical, and so this was an attempt to merely consolidate those sections into one section with no changes to the existing law.
Okay, let me just confirm that. So there is no change to existing Connecticut law. This is a technical correction to the statutes. Is that correct, LCO?
Yes, the intent was to just have existing law consolidated into one set of statutes.
Thank you. Representative O'Day, further on the bill?
Yes, Doctor, in your testimony, you're talking about, and if I may, Mr. Chair, just a little leeway, you had mentioned, Doctor, gender affirming healthcare services as being limited. What did you mean by that?
Limited in that they narrowly focus on the presenting complaint, which is the feeling that I really belong in a different gender than my body appears to be. And it tends to exclude the richness of people's personal experience, which may include traumatic experiences, OCD, difficult family structures. The exploratory therapy tries to pull all of this into a comprehensive plan for that kid or adult.
All right, and doctor, did you submit written testimony?
I did.
All right. I may reach out to you to talk to you a little bit more about it. I appreciate your testimony here today, and I thank you, the chair's indulgence for me to explore exactly what the intent of this bill was as a technical revision, and I appreciate the chair's time. Thank you, doctor.
Thank you.
Further on this bill, Representative Fishbein.
Thank you, Mr. Chairman. I guess a question for LCO, if I may. Where else does this term gender affirming healthcare services appear under the current sets of statutes?
Representative Fishbein, if you look at the sections that are being repealed in the bill, it's not always obvious when you're looking at a section that's being repealed. But the last section of this bill has a number of sections that are being repealed. So as I was indicating, the consolidation process involved taking the content of the gender affirming healthcare services sections and then adding it to the other sections, then repealing the sections dealing with gender affirming care because the content had been moved into the other section. So if you were to look at those sections that are being listed at the bottom in sections 7 and 8 of the bill, that's where you'd see that language.
And absent this legislation, you know, we had the issue of reproductive health, reproductive rights last session, that if, let's say, another state got a judgment against a Connecticut individual, that we could make them whole. They didn't step foot in that other state. I'm seeing that inserted into this concept. Am I wrong on that?
Well, so I think you're talking about a bill in 2022 that this committee did dealing with reproductive health care services, and that's still in this bill. Those are the sections.
So absent this legislation, let's just say that another state makes it illegal to render these services upon any resident of their state. And then somebody from, let's say, Texas, comes to Connecticut and gets those services, goes back to Texas, and then Texas brings an action against them. Do we have a law now that makes them whole, as we did with the 2022 situation? I don't know if you understand. I hope that.
I don't think I follow that question.
Okay, because it appears like we're taking that concept, which, you know, I took the position it was states' rights, and you know, if another state brings an action against a Connecticut resident who never stepped foot in that state, that they should be made whole. That was what we did then. It appears that same concept is being extended to this, the gender affirming healthcare.
So, no, you know, as a nonpartisan office, we would never just be extending something, you know, adding substantive provisions to the law. These laws exist already. And that's what you'd see if you were to look at sections 52-146X, 52-155B, 54-155B, 52-571. That is existing law. And so what this bill is attempting to do is consolidate the existing law into one set of laws so we don't have this duplication in the statutes.
So I'm looking particularly with regard to section it starts line 22, that change there, the insertion 22 through 36, which is that exact law that I thought we did in 2022. Am I to understand, if I look at those sections that are repealed, that the right that is created in lines 22 through 36 exists in those portions of our existing statutes?
Yes, without having those statutes in front of me, if you were to look at those repealed sections, you would see very similar language, identical language to what you see in lines 22 to 36 in those statutes.
Okay, so just to bring that all together, essentially what is happening here is we've got two different statutes that have the same basic right. We are taking the underlying condition precedent to exercising that right and putting it into one statute. Is that fair?
That's correct.
Okay.
So going forward, it was, in my view, that it was going to be confusing to have these separate statutes with different definitions. And I thought by consolidating them, it would be better going forward as we, draft in this area.
No, and I, assuming that to be I totally appreciate that action. So thank you, Mr. Chairman.
Thank you. Further questions on this technical fix? Representative Trubisky.
Thank you, Mr. Chairman, and thank you, Doctor, for coming in. Would you, no, don't go away. Would you give me your credentials one more time?
Certainly. I'm board certified in internal medicine, and that was my practice for much of my career.
Okay. This bill, we've heard discussion that it's just a technical revision. Is it your understanding that the bill removes the term gender affirming healthcare services from the definition of reproductive healthcare services?
That is my understanding.
Okay. Is gender affirming healthcare services, is that a reproductive healthcare service?
No, it is not.
Okay, so is it your feeling that this bill has is not just technical, but actually has substance to it by changing those definitions?
That's a tough question. I suppose it is substantive in that it removes the Connecticut legislature from endorsing a medical error, and I think that's a very positive step. As to whether it changes how subpoenas or requests for records or anything else might happen between states, I assume that is a purely technical issue.
Okay, when you say an error, what error are you referring to?
To confuse gender dysphoria with the reproductive system.
Okay, so now I'm looking at the definition that has been pulled out of the definition of reproductive healthcare services. And it is now a standalone definition of gender affirming healthcare services. And it says it means all medical care related to the treatment of gender dysphoria as set forth in the most recent edition of the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders. Is gender dysphoria a mental disorder?
That's a very controversial question. For years, the Diagnostic and Statistical Manual had a category called gender identity disorder. It was listed in a category of things considered sexual disorders. That was felt to be, number one, stigmatizing, and number two, perhaps not fully accurate, because people may have different opinions of their own gender that don't directly affect how they want to interact sexually with other people. So in the ESM version 5 or 6, I get confused on where this all happened, but they pulled it out of that. gave it a new category and called it the more neutral term, gender dysphoria. There is now a good deal of energy in other classification systems like the ICD to get rid of that and simply use gender incongruence. So the warning to lawmakers here is that these standards change, both the ICD and the DSM. And so if you refer to the quote, latest version, in 5 years, it may be very unclear what that latest version meant. Was it the latest version as of 2024 or as of 5 years from now?
Well, in the definition, it talks about gender incongruence, as you said, as a separate thing from gender dysphoria, not the same thing.
Yeah, the gender incongruence language does appear in DSM, but not as a primary diagnosis. It does appear as a primary diagnosis available to you in the ICD. ICD-10-CM is the current version. And it lists those diagnoses, but it tends to flatten them. They all get put into the same code. I think it's F29 or something, I don't remember. But in any event, there is a good deal of fluidity in the nomenclature around this general phenomenon.
Okay. Now it talks now that it's in a under this bill would be in a separate standalone definition outside of reproductive healthcare services. And the definition still talks about all medical care related to the treatment of gender dysphoria. And when it says all medical care, it's not talking about reproductive health care services, right?
Oh no, whatever it says about gender dysphoria, it should not be talking about reproductive health services. They are completely separate conditions.
Okay. And the gender affirming healthcare services are medical care related to treatment of a mental condition of some sort, whether you call it a disorder as it's here or dysphoria.
Mhm.
It's a mental condition.
Yeah, we don't want to be stigmatizing or think that that's a negative value judgment. It's simply something that pertains to somebody's subjective understanding and their psychological state and their understanding of their place in the world.
Okay, there isn't any age limitation on this issue, is there?
Are you talking about in the bill or in broader law or?
Well, both. There isn't anything in this bill that relates to age. Is there anything that relates to age in the medical context?
Oh, there's just loads and loads and loads of things that pertain to the age. Because if somebody is trying to make their body conform to their mind, which is the goal of many trans people, that task at age 10 is very different from at age 50. Consider somebody at 50, a male, for instance, has a deep voice and a beard and broad shoulders and is pretty tall. To go into a female role, maybe changes of dress and grooming is enough, but some people will want estrogens or they'll want to block their testosterone or even have surgery. That's a much more involved project than if you start early, which is what that Dutch protocol was all about, essentially to stop people from going through puberty with puberty blockers. So the opportunity for making changes to the body is greater when you start early, but the difficulty is informed consent and having the patient understand what they're facing. A 40-year-old thinking of going through gender transition has a pretty good idea of what life would be like after having medical interventions. A 10-year-old, how do we explain to a 10-year-old that puberty blockers and cross-sex hormones will make you infertile? What do they understand of the importance of having children? And their opinion on that at 30 may be very different than at 10. Or likewise, a girl thinking about mastectomy doesn't really think that she would never be able to breastfeed. So the issues of informed consent, how does that 10-year-old mind process things in the first place, is very fundamental to ethical considerations of gender care. And this is being debated all over the world right now.
Well, we don't allow 10-year-olds to enter into contracts.
Representative Jablonski, at this point, I am going to cut you off. I've given quite a bit of latitude, but we are straying very far from what this bill does as a technical fix, as has been discussed by LCO. You can get back to what the bill does or doesn't do, whether it's a technical fix. That is what this committee is taking up. We are not going down this rabbit hole. Understood?
I disagree that this is a technical fix. This is a substantive bill that makes a stand.
Well, Representative, you can debate that in committee, but you've heard what LCO has stated on the bill. You've asked this witness whether he agrees with that or not. We've covered this territory.
May I continue?
Not if you're going to continue down the same path, no.
You're telling me I can't ask this witness questions?
I'm telling you, if you can get back to what the bill does or the bill does not do in terms of what has been discussed by LCO, fine. But we have other folks who are here to testify today on this bill and on other bills. And out of respect for them and for the other members of the committee, we're going to constrain ourselves back to what this bill does or doesn't do.
Okay. Doctor, why do you object to this bill?
Because it allows an improper discrimination in favor of and against different kinds of treatment for gender dysphoria. In other words, it puts the state on record that says, this is our position, gender affirming care is the way to go, to the exclusion of other approaches. And to my knowledge, that has not been thoroughly investigated by the state at either executive or legislative level.
Okay, what type of care do you think it is biased in favor of?
Gender affirming.
Which is what?
Gender affirming is the care that's, it's very patient driven. A patient arrives and says, I have this strong feeling that I'm in the wrong body. Gender affirming says, okay, terrific. Let's talk about your embodiment goals, what you'd like to end up looking like, and how we can get to those. It never challenges that because the slogan is, the kid knows if he's trans, or the adult knows if he's trans. So the wider view, the classical psychotherapy of gender exploratory therapy is, I think, much preferable. But I'm not here to weigh in and try to say that the state ought to go on record favoring one or the other. I think it should favor none or favor all.
Okay, thank you. Thank you, Mr. Chair.
Representative Osborne.
Thank you, Mr. Chair. So, Doctor, I just want to make sure I understand your testimony. You don't object to the thing that is being called gender affirming care. And in fact, you support separating it from the definition of reproductive care. You object to calling it gender affirming care as opposed to gender exploratory care. Is that correct?
No, I'm not insisting that it be called gender exploratory care because that is a position with which many experts would disagree.
So is it correct that you object to a name being given to it?
To any therapy being prescribed or protected in ways that other therapies are not protected.
And that's what you think this bill does?
Yes.
Thank you very much. Questions, Mr. Chair?
Further questions or comments? Seeing none.
Sorry, I have my hand up for the second time.
Representative O'Day for the second time.
Thank you, Mr. Chair. Just along that line of questioning, Doctor, as I understand it, instead of calling it gender affirming healthcare services, what would be your preference if you have one?
Well, I think a very broad term would be services related to gender dysphoria.
And Mr. Chair, if I may ask LCO a question on this, I'm looking at lines 8 through 13, and it appears as though we're simply taking that out of section A1 and creating section A2, and putting in gender affirming healthcare services to include what is mentioned in what was formerly lines 9 through 13. Is that correct? Through you, Mr. Chair.
LCO, if you care to answer.
That is correct.
Okay.
Yep.
And we are using the word gender affirming healthcare services because is that what was utilized in prior legislation? And I apologize, and if the good chair would give me leeway here, I don't remember that being explored during our debate of the reproductive healthcare services on the floor of the House when this was done. So if the LCO staff could just confirm with me that we've been utilizing gender affirming healthcare services throughout the last couple of years throughout our statutes, and this is simply consolidating them all into be consistent. Is that what this technical fix does?
LCO.
Yes, Representative O'Day, that is correct.
Okay. And so the debate, as I recall, and I could be wrong, and the good chair will correct me. I remember going back and forth with him on this at times. I talked to the good ranking member previously. My understanding when we passed the reproductive health care services protections, there was concern that if a Connecticut doctor were performing reproductive services on someone, that somebody out of state could potentially sue that doctor, and this provides protections for that doctor performing those reproductive rights, and that's the state of the law now and has been, correct?
That's my understanding.
Okay. And so during the debate, I did not realize, so as I understand the current law then, and whether, Chair, you can answer this or else defer to LCO. So if let's say hypothetically, a father lives in Texas and they are a guardian as defined by lines, I think it was lines 90, where an authorized legal representative or guardian or patient, if the father was a co-guardian with a divorced mother, and the mother's in Connecticut, and she is allowing her 12-year-old to go through some treatment that may be permanent in nature. This doesn't change the law. This simply is a technical fix to make it clear that the mom can do that against the father's wishes and be protected from any judgment that may be sought in Texas. Is that correct?
I mean, Representative, I believe so, but at this point, we are getting a little far afield from the purposes of a public hearing. I mean, we wanted to put on the record, because this is a bill that comes to the committee at the request of the Legislative Commissioner's Office. We wanted to put on the record certainly that this is what they believe to be a technical fix bill that has been presented to the committee for review here today. But in terms of getting into hypotheticals of what current law allows or doesn't, I want to be careful, because certainly I'm not here testifying on this bill today, and I'm sure we'll have a chance to debate it in our JF week.
Yes, but Mr. Chair, as a deputy leader, I think I can understand exploring technical fixes and confirming that the technical fix is not creating new law. And I would be very surprised if the chair shut me down on that clarification.
I'm not shutting you down on that clarification. I told you, to the best of my understanding, that's correct. I believe we've heard testimony, or we've heard, I shouldn't say testimony, we've heard advice from our LCO attorney to that point. If they'd like to further expound upon that, they're welcome to.
Representative Staffstrom and Representative Day, I would just confirm that, you know, my intent was to consolidate existing statutory provisions. There was no attempt to change the law in any way whatsoever.
And I appreciate that very much, you know, and I take you at your word. I trust you implicitly on that. And I'm simply upset with myself not knowing that this was simply a technical fix. This seems to me to be more, but I trust you on that. And I will move on, and I will reach out to the good doctor separately. And I thank the chair for indulging me for the second time. Thank you very much.
Thank you, Representative. Representative Pavlik-Tomato.
Thank you, Mr. Chair. And I have to say, I have a similar statement to some of my fellow legislators on this committee. I don't remember having the conversation either. And just to clarify with LCO, is it Public Act 22-19 that was part of the statutes that you're consolidating?
So without looking at that public act, Representative Pavlik-Tomato, I do seem to recall that that was the act dealing with reproductive health care services that was before this committee.
Right. And that's the one I remember. I don't remember it. And I'm looking at it now that it's reproductive health care services, but don't remember what was the other one, if you know that statute or public act or bill that it consolidated this one with.
I think there was separate legislation that year that was dealing with gender affirming healthcare services that resulted in separate statutes being created.
Okay. And you don't have that public act or bill number?
No, not in front of me right now, no.
Okay, I apologize. I'll be taking a look at that because again, just like my colleague stated, I don't think we've ever had this conversation. So, you know, if it's hitting us as a first time conversation for many of us, of course, we just want to be thorough and make sure. So thank you very much, Mr. Chairman, for the time.
If not, sir, thanks for sitting here while we debate this.
Thank you.
Next up will be Manju Jopinathan.
Good morning, and thank you, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Manju Gopinathan Gerber, and I'm here today sitting in front of you as a Connecticut resident and as a mom and as a trained specialist, but not as an expert. This legislation appears to allow a physician to be able to sue or to be a safe harbor for a gender affirming care procedure that was performed in another state. We are a people who always want to right the injustices that occur. However, this bill seems to be giving protection only to the physicians and not to the patient, who had some just cause to hold the physician liable. If there is a fear of a counter lawsuit, who would want to file a lawsuit anyway, especially when the patient is probably a minor and cannot fully comprehend the long-term benefits and risks involved in this type of care. Gender-affirming care involves pharmacological intervention such as puberty blockers and cross-sex hormones and surgical interventions. Examples are phalloplasty and vaginoplasty. Any major surgery, of course, has risks involved, but no one can understate the high risky nature of these extreme interventions on healthy developing bodies, where these procedures include multiple surgical visits and severe complications. This type of care and complications are also associated with female genital mutilation, which occurs in different lands, an act that American women have decried for decades because it is done to satisfy social norms around female virginity and purity. Despite all the discussions of having compassion for a certain group of people, especially trans children, no one can honestly say that these extreme chemical and surgical interventions are either physically or psychologically healthy for patients upon whom they've been practiced. The truth is, no one really knows the long-term effects. I find it heartbreaking to see circumstances under which a doctor who is supposed to abide by his Hippocratic oath to do no harm and then proceed to chemically and physically sterilize and mutilate a person. All patients, especially children, need protection. And if trans children need protection, they also need judicial protection, not the physician. It's frankly a slap in the face to those betrayed by the actions of a trusted doctor to once again be betrayed by a potential law allowing a counter lawsuit or even giving them legal hurdles to get a lawsuit.
If you could summarize.
Sure. Who will then stand for them and be an advocate for them? Thank you for your time and your opportunity to speak.
Thank you very much. Questions, comments from members of the committee? Representative, I just went blank. Sorry about that. Dubinsky, thank you. Known that name for a long time. I should get it.
It's okay. I blank on names myself. Thank you, Mr. Chairman, and thank you for coming in. You started and ended your discussion talking about the effect this bill might have on liability of doctors. I'm not sure I followed. How did that work?
Sure. So it's when I read the bill, it seemed that if a person had judgment made against them in any state.
When you say a person, you mean?
Meaning a physician. Sorry about
Okay.
that. And it seems that everybody seems to be a little confused on the wording. So I just took it as a doctor who has had a judgment made against them in any state for either reproductive care or in this bill, especially was called gender affirming care. They will get a safe harbor in the state of Connecticut because we have those procedures as being legal. And in another state, it could have been banned. And that's what I was saying. It seems to be unfair to give the patient who may have had some sort of grief after that procedure to not give them a voice and let that judgment stand in another state, or why give a physician safe harbor? Or I think one of the representatives have mentioned immunity in this state. It seems like it's not really beneficial to the patient. And then who would want to sue if they had that around their head?
Okay.
That's
So you're saying that if a physician performs some type of surgery.
It doesn't have to be surgery. It can even be pharmacological intervention, as I was mentioning, puberty blockers or cross-sex hormones.
Okay,
They
so-
also can cause long-term results.
Okay, so if they, go to extreme, you've got a doctor who performs surgery on a girl, removes her breasts, and then in some other in Ohio, and then moves to Connecticut, and the girl sues when she reaches majority. you're saying that under this, if the doctor is in Connecticut, the doctor is immune from suit?
That's what it seemed to me. I mean, I was a little confused about that because
Okay.
it seems very vague. But that's what I got out of it, was that the fact that the doctor would have some sort of immunity from the previous judgment that was sought in another state.
Oh, from the judgment, so, okay, so it wouldn't be that the doctor would be sued in Connecticut. You're talking about if the doctor is sued in Ohio,
Right, and
the
then he
girl
comes
gets
to
a
Connecticut.
judgment and tries to come and execute the judgment in Connecticut.
Yes,
Okay, I understand now.
yeah, so that's what I took it as, but I'm just a layman. I'm not a law
No,
lawyer.
I understand how you could interpret it that way. Okay, well, thank you very much. I appreciate it. Thank you, Mr. Chairman.
Thank you, Representative. Representative O'Day.
Thank you, Mr. Chair, and thank you, ma'am, for your testimony. My only question was whether or not you had submitted written testimony. I see that you did.
I did, yes, but I've updated it several versions of it. I'm sorry about that.
No, that's okay. If you've updated it and so are there more than one submissions?
There are 2 submissions, and then I also submitted 2 pictures of what phalloplasty looks like.
Okay,
I don't know.
what is your background again?
I'm an endodontist and I'm also a mom.
Okay. If I don't see the pictures, if you could just get those to the chairs and the ranking members, and then maybe they can get it to us, I would appreciate it, along with, I
I
see
have
one-
them with me if you don't mind. Do you want me to show them to you here?
We
Oh,
will,
no.
we will make sure that they go to the clerk of the committee, administrator of the committee,
Okay.
and that they get distributed. Thank you. Rep. O'Day, do you have another question?
No, that's all. Thank you very much for your testimony and for your time here today. Thank you, Mr. Chair.
Thank you.
Thank you, Representative O'Day. Comment or question from other members of the committee? Comment or question? Seeing none. Thank you very much for joining us this afternoon. Next, we will hear from Jeff Cleghorn. Is Jeff Cleghorn with us? Then we will hear from Nathan Schaffner. Good afternoon. When you are ready, you may begin your testimony.
It is afternoon.
It
Good
is afternoon.
Good afternoon, Senator Winfield and members of the Judiciary Committee. I'm Attorney Nathan Schaffner. I'm a practicing workers' compensation attorney for 36 years in southeastern Connecticut. I'm also the co-chair of the Connecticut Trial Lawyers Workers' Compensation Section. And I also like to say I'm a proud member of the working group, which was the genesis of House Bill 5325. And I'm here in support of that bill. As I provided written remarks on that, I gave a history of what really brought about the importance of that working group. And I'm not going to belabor that. I'll get right to the specifics of it. But I'd like to say that the working group, we met 7 or 8 times. By my total, it was about 13 hours of meetings, probably spent about 25 or 30 hours in addition to that. But through that, we through vigorous discussion and debates and presentations, we came up with
Yeah, I was here. I don't know what happened. I was sitting here. Beats me.
Can you please mute yourself?
Specifically, the bill that's of 5325 would increase the permanent partial disability rating specific to the cervical from 117 weeks to 208 weeks. There's been some presentations in written response as well as previously that these will have a significant cost increase to employers and insurers. And I just want to give a little bit of context to the cervical injuries. Cervical injuries aren't the biggest injured body part. According to the Bureau of Labor Statistics that I looked up, they really only account for a very small amount, but when one injures the neck, it has enormous impacts on different parts of the body. It radiates into both shoulders, and it can also travel up into the head, and we see the effects of those as in terms of headaches. But neck injuries seem to have a higher rate of herniations than back injuries, at least according to the most recent Bureau of Labor statistics. So the impact, while it may not be the most expansive injury, does have important deleterious effects and impacts on someone that gets an injury. Neck injuries happen through all different trades, from heavy duty work through retail, through healthcare, as well as in clerical. So the other misconception is with this rating about it being an increase, that it would all of a sudden everyone who got a neck injury would be entitled to 208 weeks, and that's not the way it would be. It's always a percentage of that. The biggest part of which I felt very strongly about was
Attorney Schaffner?
increasing. Yes.
Could you summarize, please?
Yeah. So the second part of this would be allowing commissioners additional discretion to award benefits on the condition that the person has applied for vocational rehab and has met with a counselor. Not everyone applies for it, so they wouldn't be eligible for that additional benefit. But for those who do,
Attorney Schaffner.
then we think that these commissioners would be well-served, as well as injured workers. Thank you very much.
Thank you. And not trying to cut people off, but we want to keep people to stick to the time.
I understand. I appreciate that, Your Honor.
Comment or question from members of the committee? Representative Fishbone.
Thank you, Mr. Chairman. Is it Attorney Schaffner?
Schaffner, yes,
Okay.
sir.
Nice to meet you. I
You
thank
too.
you for coming. You know, we created this commission last session, and it's always refreshing, invigorating when somebody who's actually worked on this comes before us. So I want to do a sort of deep dive. I'm trying to figure out, how did you get to 208 as opposed to 117 weeks of compensation?
Well, that was that was through that was arrived at ultimately at the end. The original, there was discussions about where we should increase it to. Should it go up to the full amount of, which is the maximum of 520? Should it remain the same? Should it be somewhere between the 117, and previously it was prior to 1993 it was at 175. The thought ultimately came out towards the end that because of the problems associated with the neck, really have a lot of impact with the shoulder, that would be, it would, my position was it should be the same as the back of 374. But the thought was, it's because it's so connected to the upper torso as well as into the shoulders, the thought would be to equate it to the master arm rating, which is 208 weeks. And that's how the 208 weeks ultimately got proposed by the chair and voted on by the committee.
And how many people were on the committee? Do you recall?
I believe 9 or 10.
And was this a like sort of like negotiate, you know, because I think at one point it was like 5 times or something like that. It was a very high number, and now we have something sort of like in the middle of where we were. Was it like a negotiation, or, I mean, I guess my ultimate question is, what was the vote, if you recall?
I think the vote was, and perhaps co-chairman Quinn can recall that, but I believe the vote was something like 6-4 or 5-4. Not everyone was there in terms of that was on the committee when we ultimately had the vote, but it wasn't unanimous, I would say. I would say this is that what we did is, at least myself and the other attorney, Francis Drapo, did, is we thought the best way was the thought was, is let's arrive at a consensus. What can we agree on? We'll see what we can disagree on. So we came out with a sort of a working list of what our understanding was with that we've heard from our clients, we've heard from even the respondent side, claimant side, we've heard from commissioners, and we listed out all the different things, not just with permanent or partial disability, but discretionary ratings, funding, and things like that. And we came up with this working outline, if you will, very broad strokes, and let's find out what we can agree on. And you know, a lot of things we couldn't come to agreements on, unfortunately. But it seemed to be that there was a general consensus that something should be done with the neck. The neck rating is, believe it or not, a foot rating is has a higher value to it. A hand rating has a higher value to it. And so the thought is that something should be done with the neck. And so that's sort of how everyone sort of focused in on the neck. And again, the way we came up with the 208 weeks was it was my understanding that it was closer to the arm ratings, which seem to have a bigger impact at 208 weeks. And that's how we came up with that.
So, and I'm just looking at the chart here. What is the, because I don't see the word arm on the chart. What is the appropriate, where is that one?
Yeah, let me help you with that.
Sure.
If you go to the the bill itself has it in there, and you see, I think it's on page 2 of 7. You'll see that it refers to arm. You'll see master arm and other arm, 208 weeks.
Oh, I'm sorry. I was, okay.
And 194. And what this list is the statutorily determined number of maximum weeks one can claim for a permanent partial disability. The way it would work, if someone had a 10% impairment, let's say to the arm, they'd be entitled to 20.8 weeks of permanent partial disability. And this is the rating system Connecticut has. Other states have, and we discussed this at our meeting, other states, you know, these rating values and percentages don't play a role in it. What they do is they extrapolate from the rating a maximum number of weeks that one can claim a lost wage differential, if you will. It's more of akin to what we call our discretionary benefit. Connecticut seems to have a hybrid of the two. So
at the end of the day, you're bringing cervical spine into line with the master arm. That's what I'm looking at.
That's essentially it. Yeah, it seems to be that.
And I guess the position be, you know, I mean, personal injury cases that I see, you know, that are not workers' comp, almost all of them have cervical spine injuries, right? Motor vehicle accidents, I, you know, see that quite frequently, although I don't do that stuff anymore. See that quite frequently. So I can see the methodology in coming up with the 208, and I can see individuals being negative as to that, because obviously it would increase rates and that kind of stuff. But and obviously the commission itself, you know, I was expecting you to say, you know, we all agree that that felt good, you know, and it was unanimous. But based upon what I'm hearing, there was a slight tipping of the scale. So I don't know that I'm comfortable with the 208. But anyway, looking at the other aspect of this, the change is the discretion.
yes.
And I know your comments were a little truncated by the clock. You know, in the workman's comp procedure program is there to give an employee a quicker result with some sort of definitive award on basically day 2. I mean, is that fair to say? I mean, as opposed to if we didn't have this process and somebody got injured at work, your only remedy absent this process is to sue the employer, right?
That's right. Yeah. So you're right about one of the general axioms of workers' compensation is to provide a efficient, quick, and speedy remedy for an injury that occurs at work and it would provide medical care as well as lost wages. So you're accurate in that respect. The matter of the judge's discretion that we're talking about isn't something that happens at the very beginning, but more so towards the end of the case. And the problem with that has been raised about these discretionary benefits is well, they're just going to be given out willy-nilly without any basis or standards. And that's simply not true. That's a misconception that's been perpetuated for many years. First of all, the discretion the commissioner has to exercise is spelled out in the statute. You got to look at the person's age, their education, their background, their prior injuries, their attempts to try work or willingness to work. In Connecticut, we even have a restriction against this discretionary benefit if they're living out of state. So it's very clear in the way the statute delineates it. The other thing that is important to understand is that this discretionary benefit doesn't apply to every case. Many people get hurt and they go back to work and they don't have a lost wage. And that's true. And other people who do get hurt, who don't go back to their job, find other employment that's suitable. Maybe there's a lost wage there, but maybe it isn't. But so you take the full spectrum and universe of claims, and then you start whittling it down, so forth and so on. You're not ending up with this huge a value. On top of it, what came out of this, which was, I don't know if it was a consensus or not with this specific one, because it certainly, no one voted 100% for this. But one thing that came out that was a consensus is that everyone thought vocational rehabilitation, which is an excellent program that we have in Connecticut, should be utilized more. And we actually had the director testify that it's not being utilized enough. And if this is one way to help promote its utilization, then we would certainly, they would certainly appreciate that. So given at least the consensus of the committee that injured workers who are trying to get back to work should be able to avail themselves of this. But the problem became well, these discretionary benefits run out because they're tied into the number of the weeks of the impairment rating. Schooling on an average, the director said, can take 12 to 16 months. So the thought is that the third part of this bill was the funding, but the other thought is that if they apply for vocational rehabilitation, they meet with a counselor, they're either going to be into a program or they're not. But that is this type of evidence that the commissioners can take into account in awarding these additional benefits up to 2 times the permanency. Is the judge going to award it in every case? No. Are they going to award it at their compensation base rate? No. In fact, I would say most of these discretionary awards are awarded at less than the comp rate. The third thing I wanted to point out is I looked at the Compensation Review Board decisions. They're the first level of appellate decisions of a workers' comp commissioner. I looked at them. That's online from 2022 back to 1993. I came up with 70 decisions that dealt with discretionary benefits. And I said, okay, are they being abused? Are they being overutilized? And what I came up with is that of 27 were awards of these discretionary benefits that were affirmed by the review board, meaning that the appellate panel found that there was no abuse of discretion. Interesting enough is that 26 of these, they denied these discretionary benefits, and those were equally affirmed. So there seemed to be a balance on that. There were other ones where the awards, they upheld the awards, but the calculations were wrong, so they were sent back. And actually four cases where they denied it actually were reversed.
Right, but we're dealing with the expansion here, so I just want to.
It's an expansion with a caveat, and that caveat is a big one that I think
And that's where I want to stay focused right now.
Okay.
Okay?
Yes.
So the caveat to getting up to twice the benefit is applying and one meeting, because it's written in the singular. It's not completion.
not everyone becomes vocational rehabilitation. They make the determination whether you're eligible to be retrained, and they,
Okay, so somebody who applies, they meet the confines of the statute and they have that meeting,
yes,
is eligible even though they may not be retrainable.
that's right.
Okay.
Yes.
So how is that fair? Other than, I understand, you know, the worker's gonna get more money, the lawyer who's representing the worker is more than likely gonna get more money. But why would we be expanding to that drastic nth?
Well, first of all, I don't see it as as a bad thing. And I think the characterization that this is a negative because an injured worker who can't return to work and they meet with a vocational counselor provided by the state says they can't return to work, that all of a sudden that, you know what, you need some help in terms of moving on with your life, or perhaps some additional time looking for benefits, or looking for, maybe you're not eligible for retraining, but you're trying to do something else, or you find a job that's only going to pay you $15 an hour when you were earning, 25 before. So we're going to award you a wage differential for not the number of weeks of your rating, but up to 2 times. That's not a bad thing. And the other thing that I think you need to understand is that the workers' compensation system, it takes into account these lost wages as well as medical care. And if you're not taking care of people properly within the system, then they're going to go outside the system, and you're going to start finding cost shifting that occurs outside the system. And I don't think that's a good thing either. So at least allowing this additional benefit for those people who are making that extra effort. Well, let's say I'll use your example. They applied for it. They met with a counselor. Counselor says, "No, that's it." And the person says, "Well, I met for a counselor. I want twice the amount of discretionary benefits." But they haven't done anything else. Judge's discretion to say, okay, you did that. You meet that criteria, but you got to meet the other criteria too. And let's say the person's not making the effort to look for work, or let's say the person, has, enough of an education in other areas and they're not utilizing it. The judge would, as I show by these statistics, they're going to be even-handed and balanced in awarding it and denying it.
But the purpose of this system is to avoid those arguments. It is for a quick result. It is not for an argument before a magistrate, I think we call them administrative law judges now. I met the criteria of the statute. I'm a good person. You should give me the award anyway. And the other side saying, no, that wasn't the intent of the statute. And then the ALJ having to write a memorandum decision about, what we talked about today and whether or not meets. The whole purpose of this is to stay out of that realm. So why not write it that if the person is eligible and if the person does do that retraining, then maybe there's discretion then, right? And then take it away from that very low bar. I'm just, I appreciate the work that the commission did on this. And I certainly agree with the fundamental philosophy, but the condition precedent to being able to make this claim seems extremely low to me.
I don't think it's low at all. If you add the extra caveat that you just said, that you have to be in a retraining program and
complete it.
What's that?
And complete it.
Well, the purpose of this would be to award the benefit while they're in the retraining. The theory being after retraining is they're going to be out in the workforce and they're not going to need the benefit because but if you're suggesting that without that caveat of being in the retraining program is too low, I would submit to you that if you were to only limit this to those people who get in the retraining program, then you're making it too high. There's got to be some sort of intermediate ground on this. And the thought is the way to handle this is, well, they've applied for it and they've been determined not to be eligible for it. And and then it's up to the judge. Now, I would say this, 90% of all these awards, these, what they call this 308A awards, if you will, don't go to trial. They're resolved at the informal hearing. Party asks for this, respondents or for that. Parties come to a meeting. Sometimes the judges will offer their input on it. They come to an agreement and they walk forward, and that serves the purpose you're talking about, quick, expedient benefits on it. And as I said, you look at the 1,000 decisions that have occurred between 1993 and 2022, and I'm willing to submit this to the committee if they want to see this. And they're dealing with 70 of them on there. That what that's showing you is the system's working in terms of negotiated agreements that result in decisions at least the parties can live with. Some people may say it's too much, some people may say it's too less, but the bottom line is that everyone's going away discouraged. It's a good agreement. And so the system works that way. What ultimately we see is that there needs to be a pushback from what happened after 1993. And we've seen this slowly coming about. In 2019, finally, the Connecticut recognized they went too far on eliminating psychiatric claims. And now all of a sudden they're allowing certain PTSD claims for certain professions to have standalone psychiatric claims with limitations on it. We see this as just furthering that. Looking at the reforms of 93, seeing where they went too far on. Maybe some of them are good, some of them aren't, but slowly just at least helping it adapt and bringing the compact forward.
So I just want to talk about the calculation here. So I'm trying to figure out, somebody has a workman's comp claim, liver, let's say.
I haven't done a liver in a while. Let me pull
I
it
know,
up.
and that's a weird one. I know. I'm trying to think
That's
of like
okay.
hazardous substance, right?
Yeah, there it is.
In a warehouse.
Yep.
They ingest it, their liver is damaged, workman's comp claim, so on and so forth. Under the chart, they get 347 weeks of compensation. So now we have this discretion.
May I stop you?
Sure, absolutely.
Okay. First of all, they would not get 347 weeks of compensation unless they had their liver removed.
Okay.
That is the maximum. So let's say that they still have their liver, and we're not dealing with a transplant, but there's a 20% impairment to that liver. What they would be entitled to is 74.8 weeks. Oh, excuse me, 69.4 weeks. You take the percentage that is given by a medical profession. Sometimes these are debated, sometimes they're agreed to. You multiply it by the maximum of the 347, you come up with the 69.4 weeks.
I misspoke. So the
No, that's okay.
No, I appreciate the exchange. So as a result of the contamination, the exposure, the liver has to be removed. It would be the 347 weeks.
If they had a liver transplant, yes.
Okay.
And there's arguments maybe, well, they got a new liver, and that liver's, it's 100%. Why should they get 100% loss when they got a new one? But generally, that's how I understand it.
Okay, so now they have met the condition precedent of the discretion. They have applied for vocational training, and let's say they were accepted, and let's say, first of all, that they complete that vocational training. Do they get one more shot at 347?
No.
Or is it two
No.
more shots at 347?
They may get no shot, and I'll explain why that is. Look, into your scenario, the person went out and let's just assume they had a liver transplant, okay? I mean, because you're using the 100%, okay? So for a period of time, they were what's called totally disabled, unable to obtain gainful employment in their normal profession. Usually about a year after the surgery, they're the doctors assess them, and under your scenario, they would be entitled to 347 weeks of the permanent partial disability. They're not guaranteed that discretionary benefit, and this is why. Let's say they go back to their job. All right, they go back to their job, if they go back to their job, there's no lost wages. This discretionary benefit is predicated that an injury's impact is continuing and ongoing on one's earning capacity. If it isn't ongoing and continuing on their work capacity, then there's no discretionary benefit. And I would say, now when you're dealing with organs, that's a different scenario. But when you're primarily dealing with the orthopedic injuries, in many cases, people are going back to work and they're not going to be entitled to this discretionary benefit. It's certainly at the point in time when they've gone back to that job. It's only when that injury, after the impairment rating has expired, continues to have an impact on their earning capacity and is one even eligible for this discretionary benefit.
And I'm just trying to figure out, and I really appreciate, so I'm getting an education.
I enjoy the colloquy, thank you.
I'm trying to figure out, let's say they don't go back to work, right?
Okay.
So based upon the language that's before me, it says double the benefit. So does that mean they get one more of the large block, or do they get two more, which is essentially 3 large blocks?
Theoretically, if they obtained 100% liver rating, and after that permanency's expired, then what you would be able to claim is a discretionary benefit. For them to be eligible for 2 times that, they would have to have applied, at least according to the bill, they'd have to apply for vocational rehab.
No, I got that. That's
Yeah.
the condition precedent. I'm trying to get the calculation, right? So you've gotten a certain number of weeks, and we'll just say whatever the injury is, you got injured at work, you're not going back to work, you got the maximum benefit, which is 90 weeks, let's just say.
Okay.
So now you've met the condition precedent for this discretionary additional award,
Right.
right? It says the administrative law judge may award an additional compensation benefit of up to twice the duration of the partial permanent disability benefits. The way I read that is you've already gotten the 90. Now you can get an additional benefit of double the 90, right?
Oh, you're interpreting it to mean I've already got 90 weeks of discretionary. Now I can make a claim for up to another 180.
That's that's what I'm looking at. That's a big number.
That is a big number. I think the intent of this is, and I'm not trying to shortchange, but the intent is that the limitation on the discretionary benefit is the break is however many number of weeks of permanency was paid. In your scenario, it would be 90 weeks. The intent of this would be allow the commissioner to award the entirety of discretionary benefits at twice that value, not that value times 2 more. So the intent of using your scenario, the person would be eligible for a maximum of 180 weeks, not 270 weeks.
Okay, I don't think it's written that way, because it says an additional compensation benefit of up to twice the duration. So you establish the duration, and it's an additional benefit, which is twice the duration. That is 90 times 3. So anyway,
we supported the idea of allowing the commissioner's discretion 2 times the value of the impairment rating for discretionary benefits. That was our understanding of it. Obviously, if this got passed and it was interpreted that way, then I suppose it would be something a lot of people would champion. But the intent of the working group was to expand the discretion of the commission and the administrative law judges.
Without getting into more of this, I also it seems like the twice is arbitrary, so I'm sure that could,
Prior to 1993, it was unlimited.
yeah.
And awarding it and tying it to the number of weeks of the rating seemed to be too less. Other states, though, have this, as I said, this discretionary component or this lost wage component. I mean, they just have a number of weeks. In Massachusetts, it can be up to 300 and a total of like 568 weeks, but limited to 374 for this type of benefit. Rhode Island, I think it's 312. New York is in the 300s, but it's less the number of weeks of permanency paid. So each state does something different. And again, you know, we feel with the break of, at least with the vocational rehabilitation application of it and applying for it, you know, the whole thought is that someone's applying for vocational rehab to get some sort of retraining and go back to work, which happens in a large majority of cases. And if they do go back to work, then this discretionary benefit wouldn't be at their full base rate. It would be at a much smaller differential rate. But the idea is, if they've met with them once and stopped, you know, but let's say they became eligible for something and a retraining program, and they said, well, I don't want to do that. I just want to sit back and collect some additional comp benefits. That information would probably be available to the administrative law judge. Maybe they would award it, maybe they wouldn't.
I appreciate it. Thank you. Thank you, Mr. Chairman.
You're welcome.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Attorney Schaffner, I just want to thank you for your participation on the working group. First of all, I'd like to commend our Vice Chair, Representative Quinn. He put forward several proposals last year, and as it turned out, we ended up establishing a variety of working groups to try to resolve some of those and reach consensus with a variety of stakeholders gathered around the table to try to discuss and hammer these things out. And I just think that that was a really thoughtful approach. And so I give a tremendous amount of weight to the results, even though some of the votes might be 5-4. That happens in this building all the time. I personally believe that the workers' compensation system is one of the greatest boons to our country since its inception. It took a huge area where folks were getting injured and they didn't have to go through the torturous, sometimes traditional judicial system through trials. It's much more formulaic, as Representative Fishbein said, much more expeditious. And I appreciate the fact that in this instance, especially regarding the neck injury, that rather than approaching it from a merely Solomon-like, let's split the baby kind of approach, that you used as guidance the master arm, something within the universe that we can relate to. The greatest gift that any human being can have is their good health. And to have any kind of injury to one's physical capabilities, I'm sure that when you ask a lot of people, no amount of money would be worth trading it. And so the neck, to my mind, definitely bears a rational relation to a master arm. And in fact, I think to some extent, even if you have a neck brace, it's very difficult to do almost anything without utilizing your neck in some way, shape, or form. At least with an arm, you can maybe immobilize it. So I think you're absolutely on the right track. The fact that this is a high water mark, that you balance out temporary total and permanent partial, and that we're merely giving additional discretion to the administrative law judges. It's been a long time. I've been in practice now for 40 years, and it was in my first 5 years. I did a couple workers' compensation cases. I'm always happy. I was always amazed that I was actually able to succeed in one of them where my client, the claimant, was intoxicated, but he was given a chore to do that was just beyond the realm of reasonable. And so they couldn't prove that the intoxication was the direct cause of his injuries. And so I had less than the highest confidence going into that particular area. But I appreciate all your hard work and effort. And I certainly give a tremendous amount of credibility and credence to the results of the commission, and I wanted to thank you. It's hard for us to find people that are willing to serve, and I just wanted to thank you for that.
Well, I appreciate the honor. As I said, I'm a big fan of the Workers' Comp Commission. I believe it's the most efficient, best-run agency within the state. Of course, that's my understanding of it because, but I deal with it every day. I'm on a variety of different boards and I've interacted with the commission all the time. And I really believe that the sincerity and efforts of all these judges, they want to do the right thing. But the right thing doesn't always mean for the injured worker. There's an employer on the other side. So there are criteria here. And if the injured worker is going to follow that criteria, then they should be properly compensated. We're not talking about big numbers here. But if they're not going to follow it, then they shouldn't be. And I believe the commission on a whole does the right thing. Every year or every 5 years, you look at judges for reappointment and stuff. And one of the charges they have is this discretion to fashion a remedy, and I think they do a good job. So thank you very much, Senator.
Thank you. Thank you, Mr. Chair.
Thank you.
Thank you.
Representative Quinn.
Thank you, Mr. Chairman, and Senator Kissel, thank you very much for your kind words and also for selecting Attorney Schaffner to serve on the committee. I mean, if I was thinking of who I would select for this type of committee, Attorney Schaffner is certainly one of the best our system has to offer, and was someone that I would have selected myself. So again, thank you very much for doing that. And Attorney Schaffner, thank you very much for accepting the appointment. Your insight was valuable and certainly helped us to reach these conclusions. Just to dig down just a little deeper on the expansion of the 308A benefits, essentially what this would do is take a back injury, which I think we can all agree is one of the most common injuries in workers' compensation.
Yeah.
A 10% rating in a non-surgical case is going to get someone 34.7 weeks of compensation under the formula. Currently, if after the payout of the permanency, the person, because of restrictions associated with that 10% rating, and if there aren't any restrictions associated with that 10% rating, then they aren't eligible for 308A benefits.
That's
But
correct.
if they are receiving that, they would, in accordance with doing the job searches and a 308A order that the administrative law judge would get, could get that first 34.7 weeks of additional compensation.
That's correct. And again, having the restrictions is one of the predicates for it. But if they have the restrictions, the employer's accommodating them at their same pre-injury rate, there's no discretionary 308A benefits. So, but the assumption is they have those restrictions and they can't return back to that type of gainful employment earning their prior income. That makes them eligible for it. Yes.
And so what this proposal in lines 78 to 83 would do is, after the conclusion of the first round of 308A benefits, they could get a second round, assuming that they had applied for vocational rehabilitation training and met with the vocational rehabilitation specialists. And I can understand Representative Fishbine's concerns on this, and I think he and I will have an offline conversation about how we may clean this up. I mean, those of us who practice in workers' compensation read this and we know exactly what it means. But I can understand that someone else reading it who isn't as familiar with the workers' comp system might not understand what we're getting at. So perhaps there is some language cleanup we could do that would make it clearer as to what we're trying to do.
And I would be happy to assist you in any way if providing suggestions to that if I was asked.
Okay. All right. Thank you very much. And again, thank you very much for your service to our committee.
I enjoyed our meetings. Thank you, Your Honor.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today, Attorney
Thank you
General.
very much.
Jeff Clankhorn, we heard you trying to get through. If you are there, you may testify now.
Yes, thank you. Good afternoon. I speak in opposition to SB 214, and more specifically in favor of a technical fix to the definition in this bill to exclude children from coverage. I am a lawyer and was a gay rights activist for much of the past 3 decades. I served on the board of directors of Lambda Legal, and the Human Rights Campaign gave me an award. I have been a commentator on gay issues on MSNBC and CNN. What began as a good faith effort in an attempt to help adults living with the gender dysphoria or transvestic disorder DSM-5 conditions, today's queer and transgender activists have lost the script. Through growing numbers of gay men and lesbians throughout the Western world are speaking out against the transgender medical industry's targeting of children. New gay rights groups such as the LGBT Alliance, the LGB Alliance, and the Gays Against Groomers are speaking out in defense of kids. The trans medical industry pushes off-label experimental treatments like puberty blockers and wrong sex hormones, in addition to dangerous surgeries, such as amputating teen girls' healthy breasts, some as young as 12 years old. These medications are not FDA approved for this purpose, and no pharmaceutical company making them has ever sought FDA approval. Why? The reason is they have no reliable evidence any of these treatments are safe and effective long-term. Not unlike the opioid epidemic, caused and driven by greedy pharmaceutical companies and doctors placing profit over people, today's trans healthcare for kids is profit-driven. Young women and men have been harmed, as evidenced by a Reddit detransitioner group with over 52,000 members. Vaginal atrophy, sterilization, loss of sexual function, and early onset osteoporosis are among the life-altering problems experienced by kids. And just like the opioid epidemic, where we saw pain management clinics popping up all over, we now have hundreds of gender clinics, including more than 50 pediatric, where almost none existed just 15 years ago. The market projections for U.S. sex reassignment surgery, already over $2 billion a year, are projected to soar higher and higher in the coming years. Young lives, including many lesbians and gay males, are being devastated as the transgender medical industry is laughing all the way to the bank. It is time to hit the pause button in Connecticut and across the United States, and to conduct a systemic review of the medical evidence, as they have done in Europe, to investigate what gender ideology is doing to children. Thank you.
Thank you. Comment or question from members of the committee? Comment or question, Representative Trubisky.
Thank you, Mr. Chairman. And thank you for coming in. Can you give a little bit about your background?
Yes, I have been a gay rights activist for more than 30 years. I worked on the legal staff in Washington, D.C. of the Service Members Legal Defense Network from 1997 through 2003. I also served later for 6 years on the SLDN Board of Directors. I've served on the Board of Directors of Georgia Equality here in Georgia, it's my home state, and more recently on the Board of Directors of Lambda Legal. And I have devoted much of my adult life to arguing for the dignity of gay and lesbian Americans. And I know and have worked with many wonderful transsexual people and transgender people. I have represented many of them in my law practice. And I know that they only want to live their lives in peace, free from mistreatment by anyone. And of course, we support that. And thank goodness now they have every legal right, as the rest of us, thanks to the Supreme Court's recently expanding Title VII workplace protections to include transgender in its Bostock decision.
Okay, you mentioned a couple of organizations that you've been associated with in the past. I'm not sure I'm familiar with them. Would you, some of them had, you identified by some type of acronym. I apologize, I'm not familiar with those.
Yeah, sure. Lambda Legal is like the gay ACLU, a national litigation, impact litigation organization that files lawsuits across the country to historically to advocate for gay rights. The Service Members Legal Defense Network is no longer in business. We successfully accomplished our mission. I'm an Army veteran. I'm a gay man. We work to persuade and change hearts and minds of the American people that gays and lesbians can, and in fact always have, served in the military with dignity. So that's what SLDN is.
Okay, thank you. And where is your law practice?
And I'm retired from practicing law actively and was in Atlanta.
Okay. Have you been listening to testimony earlier on this bill?
Yes, sir.
Okay. Did you hear the discussion about whether or not this was just a technical bill or whether it had some substantive significance?
Yes, sir. And my understanding is the committee is also going to consider a technical fix on the definition in the bill so as to exclude children from coverage under this bill. And that's what my testimony is about, advocating to be more cautious and careful about what is happening in Connecticut and all over the country related to what is called gender affirming care for kids. And that by itself is an ideological term. It is a partisan term because we're not affirming a gender. We are actually trying to change something that can't change. No one has ever gotten a Nobel Prize for changing someone's sex because it's never happened. And children are being misled and confused into believing that if they take these hormones or puberty blockers, that they can change their sex bodies. There are 11 different studies conducted over a 40-year period, every one of which showed that overwhelmingly children with gender dysphoria, if you leave them alone, they grow out of it through puberty. In other words, puberty resolves the dysphoria. Somewhere between 61 and 98% in every one of these studies show that the children come out on the back end comfortable with their sexed bodies and overwhelmingly identify as gay men or lesbian women.
Okay, well, thank you very much. I appreciate your responses and thank you for coming in and testifying. Thank you, Mr. Chairman.
Thank you, Representative. Are there comment or questions from other members of the committee? Comment or questions? Seeing none, thank you very much for joining us today. Christine Rebstock.
Good afternoon, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Christine Rebstock. I'm a transsexual woman from Middletown. I am also the Executive Director of Media and Communications for LGBTS United. When I saw SB 214, I'm opposed to this bill. How does reproductive care and gender affirming care go together? Well, let's see. Puberty blockers, which are administered to kids under age 14, which also have Lupron in, and which is used to castrate sex offenders and being sold as safe and reversible, by the way, is not reproductive care. I have with me spironolactone and estradiol. These are my prescriptions for hormone replacement therapy. Spironolactone being a testosterone blocker, estradiol being my estrogen. And I will be on these to the day I die. Is that reproductive health care? No. How about surgeries, like the 6 double mastectomies that were performed at Hartford Healthcare from a period of 2017 to 2020? Those are trans boys, and they had their breasts removed. Paid by Husky, by the way. Also not included was a minimum of a year of hormone replacement therapy, which is required before your surgeries. Is that reproductive health care? No. Gender affirming care. These matters are separate. It's apples and oranges. And transsexual, as Mr. Cleghorn brought up, I transitioned my body. I look like a woman. I can, thank God, He gave me the ability to blend in as a woman and get treated as a woman. But today, tomorrow, and no day will I ever be able to have periods or get pregnant. The gender affirming care is about dealing with your dysphoria. It will not change your biological sex. And that's a misconception that we're seeing to our young children. Trans matters, it's a very hot topic. I will make myself available to not only the members of this committee, but to every member of the Connecticut State Legislature. You are more than free to reach out to me on such issues. Thank you.
Thank you. Comment or question from members of the committee? Representative Dubitsky.
Thank you, thank you, Mr. Chair. Thank you for coming in. Very much appreciate it. I'm looking at this bill and it has a definition of gender affirming healthcare services. And it talks about the treatment of gender dysphoria. You had mentioned gender dysphoria and that you suffer from that
Yes,
affliction.
correct.
Is it your feeling that as this definition appears to imply that it is a mental disorder?
I prefer to use the original term that was up to 2013 called gender identity disorder. It is a mental health and medical disorder. So to answer your question, I live with a disorder. I believe mental health aspect of trans healthcare has been diminished in the last decade. You definitely need mental health gatekeeping. The lack of it is why we see people detransition. Detransitioners are those who have started transition medically or even social transition and realize they regret it. At the end, they didn't have proper mental health vetting. Transitioning medically is the very last stage you want to be at. You have to be sure you are dysphoric. And it has worked out for me. But I do live with the disorder, to answer your question, sir.
And so you receive treatment for that?
Yes,
Okay, mental health treatment.
mental health treatment.
Is it your understanding that mental health treatment is within the definition in this bill of gender affirming healthcare services?
I'm not sure about it, but it should be. We live in a day and age where one could go to Planned Parenthood and say you have gender dysphoria and you're walking out with a prescription for these or testosterone for someone going female to male without any mental health vetting.
You know, this bill appears to remove gender affirming healthcare services from the definition of reproductive healthcare services. Is it your feeling that they should be separate, that they're two different things?
Yes, they are different things. My health care is not reproductive health care at all.
All right, well, I very much appreciate your coming in and talking to us about it. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much.
Hello, I'm sorry, Mr. Chair. Couldn't get
I
my
was
hand.
looking, I didn't see the hand. I see it now.
Sorry about that. I'm going back and forth between transportation and judish. Thank you very much for your testimony. I'm just wondering, did you submit written testimony?
Yes, I did, sir.
Oh, thank you very much. I'm going to look at it, and if I have any questions, hopefully you'll be amenable to me reaching out to you.
Absolutely. In fact, yourself, as I said, anyone in the entire Connecticut State Legislature, you're more than welcome to reach out to me.
Thank you very much. Really do appreciate it, and thank you, Mr. Chair.
Thank you, Representative. Oh, enjoy your afternoon.
Thank you.
Representative Piscopo.
Thank you, Mr. Chairman. Rep. John Piscopo, 76th District. I want to thank the chairman and ranking members, the vice chairs, and the members of this committee for raising House Bill 5256, an act concerning liability for injuries inherent in camping while at a private campground. Over the years, and especially this session, great pains have been taken to craft the language to create, to get a balance between the campground owners and those campers. And I think we've come up with some very good language, and I want to thank all those people that helped me with this language. And you know who you are, and some even members of this committee in the past have helped me with this language. So I want to just thank this committee very much for raising this bill. And it's a small step in that direction to try and get a balance, as I say. So thank you very much.
Thank you, Representative. Comment or question from members of the committee, Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, Representative Piscopo. I'm trying to figure out what harm are we looking to prevent from this legislation?
Well, I could say that the title it gives you the intent and the basic reason for this bill. The harm is inherent risk, as in the title says. A person, your example earlier, there's a bee's nest. That's kind of inherent risk. Was the bee's nest on a nature trail, and the camper wandered up on a bee's nest by accident and was stung? Or was the campground owner notified of the bee's nest and did nothing about it? Didn't put up a warning sign, didn't rope off the area, and so that kind of thing. That's the kind of thing I'm after. Just basic language to just try and help the campground owners just move in the right direction.
So I'm trying to figure out, liability for, let's say, a restaurant. The restaurant has an outdoor dining area. And we'll impute the bee's nest situation to the restaurant. Should this legislation pass, restaurants would be treated differently than a campground?
Yes, I would, my interpretation of the language would be yes. The campground falls in a very, a niche, if you will, with the ski areas, the Christmas tree farms, and the equestrian centers. It's that kind of, it's just that kind of business. It's that kind of organization, and it fits very well in with campgrounds. I mean, ski areas, and Christmas tree farms. It just kind of falls in that, whereas restaurants necessarily would not.
So, I hate to eat outside, quite frankly, because they charge you the same amount of money, you get the bugs and stuff, right? Or you get the birds and all that stuff. But, and I'm trying to, I've been to some restaurants that have an outdoor area, and I'll see the hornet's nest over there in the corner, right? So we'll take the two and keep them at the same plane. A couple of the waiters at the restaurant have been stung by the hornets, and they tell the business owner, they don't do anything about it, and then a patron is stung by the hornet and dies. I think there may be, you can at least file a lawsuit. Whether or not, jury ultimately determines his liability is a different question. But am I to understand that only if there's notice to the campground of a similar condition and they don't do it, that is the only scenario under which there would be liability?
I think the short answer is yes. I would draw your attention to line 17 and 18, sub 1, commits an act or omission. If he commits an act, he just just refuses to do anything about it. Or omission, that means that he just omitted it. He just was told that there's a business there, does nothing about it. If I'm a campground owner and someone says, there's a bee's nest on the nature trail 50 yards in, I will rope off that nature trail. If it's in the middle of the day, bees are all over the place. I'm gonna rope off that trail. This trail is closed due to hazards. I'm gonna put up a sign. Please don't use this trail. It's hazardous. It's closed today. And I'm gonna go back first thing at dawn and take care of that bee's nest, or leave it totally closed, whatever the campground owner wants to do. So I think that's, I think this gives the campground a little bit of protection in that area.
Okay, I thank you. Thank you for your response, and thank you, Mr. Chairman, for the opportunity.
Thank you, Representative, and I agree with you on that outdoor dining. I'm the same way. I never go outdoor.
Thank you, Representative. Representative Dubisky.
Thank you, Mr. Chair. Thank you, Representative, for coming in to discuss this bill. My questions center around the definition of private campground. I see that it is a place where 5 or more campsites are made available for use as temporary living quarters for recreation, camping, travel, or seasonal use. How did you, if you know, was that definition derived, that it's 5 or more campsites?
I don't know how 5 came up. I would, you have a good amount of testimony from campground owners, and they do address that section right there, that subsection. They address it in their testimony. I think it's in the 40s anyway, Representative, of campgrounds in the state. And a lot of them have submitted testimony, which I'm very thankful and they will help me answer this question better in their testimony.
Okay, well, I certainly appreciate that, and we'll take a look at their written testimony. So this is not designed, like there is a new kind of fad of sort of almost like a Airbnb for campsites. I think they call them semi-primitives or things like that, where you know, a lot of people out in the rural areas are now charging people to come live in the barn for a couple of days, or, you know, have a little campsite down near the stream. This doesn't seem to be intended to capture that. This seems to be more to capture the established commercial campgrounds. Is that your impression?
Yes, and that was my intention too, also, Representative. I've seen that also in my district, corners of my district. It's starting to, you go by a property and there's 2 or 3 campers in the guy's yard or field.
Okay. Well, thank you very much. I appreciate it. Thank you for coming in. Thank you, Mr. Chairman.
Thank you, Representative. Representative O'Day.
Thank you, Mr. Chair, and thank you, Representative, for your testimony and advocacy for this legislation. Is this the first year? I have a recollection of you doing this in prior years.
Yes, about 3 years ago, it got sent to the Environment Committee where we both serve. And so I think that's part of your recognition and recollection. And yeah, I've been at this for a while. We studied other states. There's about 4 or 5 other states. I tried to 1 year craft it after Indiana, which seemed like the best law at the time. And I've been, you know, I've just been trying to get the proper language where both parties can agree. And you have the right you have good memory, Representative.
Well, and I'm looking at it. You seem to have narrowed the scope and requiring posting and whatnot. I tried to see if about any opposition testimony. I didn't see any. Are you aware of any opposition testimony?
No, it looks like it's all in support. The testimony come to this committee. And
Right.
I'm very appreciative of that. Anybody that submitted testimony, even if there was some in opposition, but I didn't see any opposition testimony this morning as I checked. But of course, I'll double check and try and address any comments that may be adverse.
Well, thank you very much for your advocacy, Representative. I think you're our most senior or experienced, let me say experienced representative on this side of the aisle, and we appreciate your years of service, and thanks for bringing this to our attention.
Thank you, Representative, and I may be more senior also. I appreciate it.
Nothing wrong
Thank you,
with
Mr. Chair.
You are welcome. Senator Kissel.
Thank you very much, Chairman Winfield. The longest serving Republican senator to the longest serving Republican House member. Great to see you at our committee. And I think that you've done a really good job in trying to make this. I mean, the fact that you had a room filled with trial lawyers and then they didn't beat this bill up, that says a lot. And so I certainly support your efforts and will do whatever I can. And really nice to see you here in our committee.
Thank you very much, Senator, for those words. And I'm grateful for the help the trial lawyers gave me. Of course, they wanted to craft as good a policy as possible. And they were very courteous, very, very courteous. I owe them a great deal of thanks. So thank you, Senator, personally. I appreciate it. And I hope the entire committee sees fit to report this out favorably.
Thank you, Representative. I don't see any further questions or comments, so I want to thank you for joining us this afternoon.
Thank you again, Mr. Chairman.
Ed Hawthorne.
Good afternoon, Senator Whitfield, Representative Sastrom, and members of the Judiciary Committee. My name is Ed Hawthorne. I'm proud to serve as the president of the Connecticut AFL-CIO, federation of hundreds of local unions representing nearly 250,000 workers here in the great state of Connecticut. It is on their behalf that I testify in favor of HB 5325, an act concerning payments and benefits to individuals with partial permanent disabilities. First, please allow me to thank Representatives Quinn and Conley for their work on this issue as co-chairs of the Injured Employee Partial Permanent Disability Payment Working Group. They reviewed the level and the benefit, the outcome of this and the result of that is the need for an increase from 117 weeks to 208 weeks for cervical spine injuries. That allows workers' compensation, administrative law judges to award an additional benefit up to twice the duration for partial permanent disability benefits if the claimant has applied to participate in vocational rehab program and has met with a vocational rehabilitation counselor. As we all know, workers' compensation has historically been referred to as a grand bargain that's struck between workers and employers. What this bill seeks to do is update the current statute. Since the 1993 amendments were implemented, so much has changed. Workers' compensation statute needs to be modernized with new advancements in neck fusion, disc replacement, and other surgical interventions, giving workers hope to gain back that full range of motion, be made whole. But often they need longer to heal and undergo physical therapy to reach that full potential. Excuse me, reconsideration of these benefits is imperative as the new strides in science come forth. We applaud the incentives of the workers to make full use of the vocational rehabilitation. We are also mindful that the insurance industry will oppose this bill, suggesting that there's insufficient data to justify the changes included in the bill. As insurers, they have the statistical evidence to demonstrate the opposite. We have yet to see it from them. In addition, it should be noted that employers' workers' compensation premium rates have decreased for 10 consecutive years, resulting in cumulative savings of more than $300 million and reduced premium expense for that employers. Just last year alone, employers saw a nearly 10% decrease. This bill is just a modest revision that will not significantly impact employers. Workers suffering partial permanent disabilities are struggling to survive because they sustained an injury at work. As society, we have an obligation to ensure that we provide sufficient supports to allow them to recover and resume their livelihood as much as they possibly can. We urge the committee to support the bill. Thank you for the opportunity to testify. Thank you for being flexible. I'm actually at IBEW. I wish I was there in person with you, but thank you once again. I'd be happy to answer any questions you may have.
Thank you. Comment, question from members of the committee. Comment, question. Seeing none, Mr. Hawthorne, good to see you again. Thank you for joining us.
Thank you.
Next, we will hear from Lisa Amatruda.
Good afternoon, Mr. Chairman, members of the committee. My name is Lisa Amatruda, and I'm from Woodbury. I'm submitting verbal and written testimony opposing the changes in SB 214. I'm particularly concerned about the immunity given to doctors who perform gender-affirming healthcare on children. I'm a small business owner of a gas station and convenience store. We do not let minors buy alcohol, cigarettes, vapes, cigars, or even lottery tickets. But somehow we think it's okay for children or minors under the age of 18 to make permanent, life-altering decisions that have long-lasting and devastating consequences for the rest of their lives. Children cannot give informed consent. I raised 4 children, and they were actually all teenagers together. Anyone who's raised or is actively raising children knows that it's nearly impossible to explain to children the long-term impacts of some of their decisions. And more importantly, we don't even seem to be trying when it comes to this issue of gender dysphoria. The standard of care seems to be immediate, permanent medical intervention. Children can wake up one day and decide to go into Planned Parenthood and begin the process of receiving gender-affirming healthcare services, as this bill is worded, that very day. They can begin taking puberty blocker medications that day and also schedule an appointment to talk to a doctor for surgery to remove their breasts. This can be and often is without the knowledge of their parents. Does anyone take the time to address the underlying mental health issues these children may be going through? What happens when they wake up in, I don't know, another 5 or 10 years later and decide they want to have their own children, find out they can't? They deserve the right to hold the adults responsible. For example, their doctors, counselors, mental health workers. The people who do this to our children deserve to be held accountable. And I implore you to please not take that away from our children. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us.
Sorry.
Oh, Representative O'Day.
I apologize, Mr. Chair. I'm going back and forth between this and transportation. Thank you, Ms. Amatruda, for your testimony. I understand you submitted written as well. I'm sorry I didn't get to read it yet, but I will. And I agree with you. I have the same concerns. This is a technical bill right now, but I will read your testimony and reach out if hopefully you have your contact information on there. But thank you.
Thank you, Representative O'Day. I will add my contact info.
Thank you.
Thank you,
Thank you, Mr.
Representative.
Chair.
Yep. Thank you, Representative O'Day, and thank you, ma'am, for joining us this afternoon. Steve Ward. When you are ready, you may press the button and you have your 3 minutes.
Mr. Chairman and committee members, my name is Steve Ward. I'm a board certified internist. I live in Cheshire. I've been practicing primary care for about 15 years. And I'd also like to oppose SB 214. I do understand, I've been listening to the conversation about the technical focus of today's session, but I do want to point out that there's a problem in the definitions as I read them here in section 1A, the first paragraph, where it discusses reproductive healthcare services. And it specifically says includes all medical, surgical, counseling, or referral services. I'm specifically happy to see counseling services is included. However, the proposed new language where gender affirming healthcare services means all medical care only says medical care there. So to my mind, this reduces or eliminates the applicability of counseling resources for people who are suffering from gender dysphoria. I have an additional concern with the linking of the language in this bill to definitions provided by the American Psychiatric Association and also the ICD, which comes out of the World Health Organization. Back in 2013, the gender identity disorder language was taken out of the DSM, and gender dysphoria was then put into a new category within the updated version of DSM as a sexual disorder, meaning that patients with gender dysphoria are suffering from disorder that has more of a biologic or genetic type of a physical basis. So there's an assumption there, and that assumption is actually what is quite controversial. And this bill, I understand, is more technically focused with consolidation of language, but I wanted to at least get this into our minds if this goes to discussion in a different forum, and I'd be very happy to help with that. I'm concerned about the redefinition of terms of medical care being exclusively referring to medications such as puberty blockers, hormone therapy, or surgery, to the exclusion of counseling. And often culturally, we use the language of compassionate care in patient care in general, but that language is being used more culturally speaking to mean that we must agree and affirm the feelings of the individual rather than help that person understand the mental health component of their experience of gender dysphoria. Thank you for having me.
Thank you. Comment or question from members of the committee, Representative Dubinsky.
Thank you, Mr. Chair. Thank you for coming in. You raised an issue I'm not sure I had noticed. So in the definition of reproductive health care, it includes medical, surgical, counseling, and referral services. Is it your understanding that surgical, counseling, and referral services are different from medical services?
Correct. I think people may differ in that definition, but that's the point, is that I think we should specifically articulate medical care and counseling services under gender affirming healthcare services as well.
Gotcha. And so my interpretation of what you're saying is that by removing the gender affirming healthcare services definition from reproductive healthcare services, it leaves behind the surgical, counseling, and referral services only in reproductive healthcare services. It doesn't bring it with it into the separate definition of gender affirming healthcare services. Okay. I think one of the previous witnesses also had the same issue, but perhaps it just didn't click in my mind when I heard that testimony.
The removal of the counseling services, for example, assumes that we have a medical condition biologically based, but that assumption is the very thing that is controversial.
Well, is it controversial for everybody, like for all patients, or is it controversial because well, tell me why there's a controversy.
Well, I think people who are pushing gender affirming care as an ideology believe that the dysphoria is due to a mismatch between their body and their mind. But the assumption is that the body is what needs to be changed. But that's controversial in the sense that we don't have medical evidence for that, but also a lot of the studies that are often used to support gender affirming care do not adequately tease out the underlying mental health disorders of the people who are presenting with the gender dysphoria. So there's this assumption that the problem is biologically or physically based, therefore needs a biological or physical solution, such as medication or surgery, when in fact my contention is, and I think the contention of many, is that gender dysphoria is primarily a mental health disorder that needs mental health resources. And that's why I'm trying to make the case that we should include that language so that counseling would be recognized as a valid method of treatment.
Do you agree with the reference under the definition of gender affirming healthcare services to the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders? I'm sorry, you got your buttons
Your
off.
microphone is off.
Sorry. I do not. I think the American Psychiatric Association mistakenly removed gender identity disorder out of a mental health category into its own exclusive category and renamed it gender dysphoria. I think that was driven more by ideology than science. So I do disagree with the APA in that sense. So I think there's just a lot of discussion and debate to yet be had. And I would just hate to see the definition in this bill linked to the American Psychiatric Association or the ICD, which I feel is an incorrect definition that can lead to many unpredictable paths.
Are there other definitions that you're aware of? Perhaps one that would be better than the one that's proposed in this bill?
I think if the language was more generic, if it just simply said gender affirming healthcare services, meaning all medical care and counseling services relating that condition, I think that's an adequate definition, because I think to be more specific would be difficult to achieve.
How is it done elsewhere in the world? Do you know? Like, probably like in Europe, is there a different definition?
My best understanding is that in other parts of the world, such as Europe, they use a similar definition, but I believe that's problematic. And we've seen many countries in Scandinavia, Sweden, Norway, for example, that have been doing this for over 30 years. They're backtracking now because I think they're now seeing that they got this wrong.
In what way are they backtracking?
Well, gender affirming care, especially for minors, is now either banned or severely restricted in many of those countries. Sweden, Norway, Australia, New Zealand, I believe, several others. It's a growing list.
All right, well, thank you very much. I very much appreciate your testimony. Thank you, Mr. Chairman.
Thank you. Representative O'Day.
Thank you very much, Mr. Chair. And thank you, Doctor, for your testimony. I looked for, did you submit any written testimony?
No, I didn't.
Okay, good. There's a Brendan Ward who doesn't appear to be a doctor. So I wanted to make sure, I don't want to certainly put any more work on you, Doctor, with your busy schedule, I'm sure, but if you could submit written testimony, I'd appreciate it.
Sure.
So I would like to reach out to you. Although my father was a practicing general surgeon, I did not stay at a Holiday Inn Express last night, and I don't think I learned much at the kitchen table. So I would appreciate the opportunity to reach out to you and discuss this further. As you've heard, this is a technical change to the legislation. I just need to educate myself more on your expertise and your thoughts. So if you're willing to do that, I would appreciate the opportunity. Thank you.
Sure, we'll do. Thank you.
Thank you. Comment or question from others? Comment or question from others? Seeing none. Amity R. Scott. Amity R. Scott. If not, Michelle Cortella.
Hello, good afternoon. Thank you, Mr. Chairman, Senate Judiciary Committee. My name is Dr. Michelle Cortella. I am a pediatrician who is a consultant to several attorneys who are presently litigating on behalf of detransitioners against doctors who provided them with gender affirming care when they were teenagers. And these young women have had their mental and physical health devastated by that care. So I am speaking as the Lambda legal attorney did earlier toward a technical fix to the definition of gender affirming care in SB 214 to exclude children and apply only to transitions for adults. The detransitioner cases that I have reviewed, they are now women in their 20s who've sustained permanent damage, including painful intercourse, inability to orgasm, permanent broken voice in their words. Potential infertility. They have extreme PTSD, depression, anxiety over the thought that they are very likely infertile and they will never get their functioning breasts back, never be able to breastfeed a baby if they are able to have one in the future. Every detransitioner was first a minor, a child with gender dysphoria who fell prey to social contagion and doctors who pushed them into medical and surgical gender affirming care, despite a laundry list of a long past medical history of multiple traumas and mental illnesses that they did not treat or resolve. And there are rigorous studies to show that this is not the exception. It is the rule that most young people with gender dysphoria have a long past medical history of other psychiatric illnesses that require care. There are now 7 systematic international studies to say that gender affirming care given to minors is experimental. There is no strong science to support it. As a result, we know, for example, there are significant harms that can come from puberty blockers and cross-sex hormones when you give them to minors, such as permanent sterility, and increased risk of heart attacks, blood clots, strokes, and more across the lifespan. For that reason, as the previous physician mentioned, we now know that the UK, Sweden, Denmark, and Finland have restricted pediatric gender transition to clinical experiments, to clinical trials. And these countries now mandate psychotherapy as the first line of treatment for these young people because they do not want to have, we're going to here in the United States see a tsunami of detransitioner lawsuits in the near future. And so it is my hope that the technical fix to the definition could be made. Thank you.
Representative Dubisky.
Thank you, Mr. Chair. Thank you for coming in. Would you state your credentials again? I'm not
Sure. I am an MD. I am a pediatrician. I practiced general pediatrics with a focus in behavioral mental health for 15 years in Connecticut and Rhode Island. And for the last 10 years, I have been devoting my time to scientific research, reviews of the literature, particularly with regard to gender affirming care and how it impacts children.
Okay, so you're an MD?
Yes.
Okay, and you part of your practice is or was behavioral health care?
Yes, for the 15 years that I was in general practice in Rhode Island and Connecticut, I cared for babies through children, quote unquote, to age 21, actually. And yes, I had a focus in behavioral health.
Okay, and is it your feeling that gender dysphoria is a behavioral health condition?
It is, I am not the only one to believe this, but a very recent study out of Finland. So the short answer is yes, but I want to reference a very recent study out of Finland that found they looked at all adolescents defined as young people under age 23 who approached the gender clinic in Finland, and they're socialized medicine, so their records are outstanding. And they found when they compared those seeking, the young people seeking gender affirming care to transition, and they compared them with the general population, aged matched controls, the researchers wanted to discover what was the cause of, what would predict death by suicide. And what they found is that the gender dysphoria was not linked to suicide at all. Whether you were a young person in the general population or a young person seeking to transition for gender dysphoria, death by suicide and all-cause mortality deaths were related to other mental illnesses. So it is my belief and the belief of many others that in the case of young people, mental illnesses, traumas, things such as autism spectrum disorder, these factors can predispose to a person feeling divorced from their body. So that's one of the hypotheses out there. But it's, so yes, that's a long answer to your.
Now, I think I heard you say you were involved in litigation with regard to
I am a
detransitioners?
Yes, I am a consultant to various legal teams. I'm not allowed to disclose any specific.
I
name.
wouldn't ask you about
Yeah,
a
because it's
specific
active.
case.
Yes.
Is there any standard of care for a doctor to perform a double mastectomy on a child?
So currently and ever since gender affirming care was launched in the US, first at Boston Children's Hospital in 2007, the physicians, the practitioners refer to WPATH, the World Professional Association of Transgender Health, and there's quote unquote standards of care. First, it was the 7th edition. Now we're in the 8th edition. But the fact of the matter is these standards of care are, they just removed in 8th edition, took out all age limits
Representative.
relative to both drugs and surgeries. So there are no true standards of care, which is why the best science we have are the international systematic reviews. 7 of them now. One just published last week out of Germany, which has found that there is no strong science to claim that transitioning a child with blockers, hormones, and/or surgeries is safe or effective. And we have the strong study out of Finland published just a week or 2 ago. Again, as I indicated, they found no association between gender dysphoria and suicide. It was the comorbid, the accompanying psychiatric illnesses that were ignored by the gender affirming team. That's what predicted the suicide. Additionally, that same Finland study found that transitioning did not protect against suicide in those young people.
Representative,
Thank you very much.
I'm just gonna remind you to stick close to the bill itself.
I'm finished.
Thank you.
Thank you. Thank you, Mr. Chairman. Thank you very much for coming in. I very much appreciate it.
Representative O'Day.
Thank you, Mr. Chair, and thank you, Doctor, very much for your testimony. Look, as I've already stated, I'm not an expert in the field. I looked for your written testimony. I didn't see it. I'm wondering if you submitted any?
I can submit it to you. I did not submit that.
If you could submit it, I'd like to see those studies, particularly the Finland study and the German study you made reference to, but anything that you could submit would be greatly appreciated. Obviously, this is, as you've heard discussed, this is a technical bill, but you bring up a lot of good points that I agree with completely, and we may have an opportunity to address this at a later date. But thank you, Mr. Chair, and thank you, Doctor, for your testimony.
Thank you.
Thank you, Representative O'Day. Don't leave yet. I just have a question because
So sorry.
You are a consultant, you said, to some cases. And you put forward that there's going to be a tsunami of transitions. Do you know what the rate of detransition is?
So the most recent study we have is that regret among young people could be as high as 30%. I'd be happy to submit to the committee a scientific commentary, which indicates why that may be an underestimate. My gut feeling, so that comment, that gut is coming from what I'm seeing 2 places, online in detransition groups, as well as just seeing the most recent science. We meaning medicine generally, my profession, pediatricians, as well as psychiatrists, et cetera, we're not helping these children or young people who have they're suffering. My prediction is that, my personal prediction is that we're going to see a.
I understand that. I just want to know what you currently actually know.
So
So that's why I'm asking you about the rate of detransition.
the most recent, yeah, 30%.
And where does that come from? Because I've done some research on this. This issue comes before us from time to time in one way or another. And my understanding is the overall detransition rates are significantly lower than that. So that number seems particularly high. I will not dispute that there is stuff out there that suggests that. But on the type of research that's been reviewed, I've never heard that number.
Correct. That is, those studies are looking at adults who transitioned as adults. Those studies, and they will generally say there's a 1 to 2% rate of regret. But again, that's focused primarily on adults, and those aren't more recent. Looking at this is a different and newer population.
Okay, I would be very happy to receive that. I've done a lot of research on this, so that would be helpful. Okay.
Very good.
And the only reason I asked, as you notice, I haven't been talking a lot is because you put out the tsunami. So I just want to make sure that the information we put out is accurate. So,
Thank you.
Thank you for joining us, Dad. Bud Drapo.
Yes, good afternoon, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Bud Drapo, and for over 30 years, I have advocated on behalf of injured workers. I'm a former chair of the Workers' Comp section of the Connecticut Bar Association, and I'm here to testify in support of HB 5325, an act concerning payments and benefits to individuals with partial permanent disabilities. I also sat on the working group that helped to produce this bill. I'm excited about this bill. It's a very important bill that closes the disparity in the treatment of lumbar and spine permanent impairment. And it also provides greater access to retraining for injured workers who are unable to return to their former occupation. I know I submitted written testimony, and I know a lot of ground has been covered today, and I just wanted to take my time to focus everyone on the additional discretion for the judges in awarding 308A benefits. I want to focus everyone on what the situation that we're dealing with. We're dealing with an injured worker whose injuries are so severe that they have permanent restrictions that won't allow them to return to their chosen occupation. And coupled with that, their employer is unable to accommodate those restrictions and find them another job. So what are we to do with these folks? Well, obviously the best answer is retraining. And we already have effective retraining programs. The problem is, while the retraining is free, there is no way for these folks to pay their bills while they're in retraining. And that's why HB 5325 provides a solution to this by extending 308A benefits, or at least the discretion of the 308A benefits, for those who have applied to the retraining program. And I can't emphasize enough how important this is, because if these folks aren't retrained, they fall through the cracks and they fall into the safety net of other state social programs that are funded by taxpayers, obviously. They don't just simply go away. I'd be happy to answer any questions that you may have.
Questions from the committee? Seeing none. Thanks, Spinless. Peter Myers.
Good afternoon, chairs, ranking members, and members of the Judiciary Committee. My name is Peter Myers. I'm a public policy associate from the Connecticut Business and Industry Association, where I cover workers' compensation as well as several other areas of concern for business owners. I've submitted written comments on this for CBIA with our testimony, and I will summarize rather than read it to you, if that's all right with you, everyone. CBIA is in opposition to House Bill 5325 today, a bill that would unfortunately increase the cost of workers' compensation insurance for our state employers. at a time when recently it was reported that 91% of employers in the state of Connecticut are reporting an increase in overall costs. This bill, specifically focusing on Section 2 first, would undoubtedly increase the cost of doing business in Connecticut. Section 2 would give the ability for a 100% increase in 308A benefits if an injured worker has only applied and met with a vocational rehab counselor. Unfortunately, we believe that an increase in these benefits would lead to an increase in insurance premiums paid by our state's employers. And then moving on to Section 3 of this bill, where it instructs the Department of Aging and Disability Services to, within appropriations, offer a stipend to individuals who are in vocational rehabilitation programs. And as the committee is aware, funding for this rehabilitation program in part comes from assessments that are paid for by employers. So increasing the stipend or increasing the funding for the program would mean an increase in assessment on employers. And we would just like to make the committee aware of that. And then in closing, while the business community of our state believes that encouraging injured workers to utilize vocational rehab is a laudable goal, when coupled with a significant increase in the worth of a cervical neck injuries from 117 weeks to 208 weeks, which is included in Section 1, CBIA is concerned that these substantial changes will increase workers' compensation premiums and the assessments that are paid for by employers at a time when 91% of business owners are saying costs are increasing. So CBIA urges the committee to please respectfully oppose this legislation. Thank you.
Questions or comments? Representative Quinn?
Thank you, Mr. Chairman, and thank you, Mr. Myers, for being here today. Has CBIA done an analysis as to how much they think this is going to have costs rise?
Thank you, Representative. And first, thank you for chairing the working group. I was not on it, neither was CBIA, but getting to watch it was something we really appreciated. And in terms of running the numbers on it, we have asked NCCI just for their thoughts on it, and they indicated to us that it would be very difficult to price the expansion from Section 2, given the current framework, because it's fair to assume that a trial attorney would take their client right away to apply and meet with the vocational rehab program just to be eligible for the benefits. So to give a firm number, they weren't able to do that right away. But it's something we can certainly look at.
Okay, so it's possible then that any increase could be minimal.
I would say that I think it's fair to assume that a potential double increase in benefits would be an increase to business owners in Connecticut. I wouldn't be able to say what the increase would be, but as I would say, in this bill, there are 3 areas in one bill that would potentially increase costs for business owners.
But if we're steering more people towards vocational rehabilitation training, doesn't that ultimately have a benefit for employers in Connecticut, with more people being able to work even though they have an injury that may have caused them to not be able to do the type of work that they had been doing?
I would say, as I said in my testimony, that people going to vocational rehab is a laudable goal, and we want to see injured workers be able to utilize that. We just want to make the committee aware of the cost of expanding that with a stipend, or a cost of expanding the benefits to cover that. There would be a cost borne by our state's business owners.
Okay. All right. Thank you.
Thank you, Representative.
Representative Fishman?
Thank you, Mr. Chairman. Good afternoon. Can you just explain to me how, we heard earlier that if somebody had a liver transplant, then they would, the max payout or the max compensation is 347 weeks. How does one get to the max reward for a cervical spine?
I don't think I'd be able to weigh in on that as not being a practicing workers' compensation attorney or a medical doctor. I wouldn't be able to weigh in on how they would get to that award amount. I apologize.
Okay, no, I'd rather have an honest answer.
Yeah.
No, I appreciate honesty. And then you had said, were you here earlier when Attorney Schaffner testified?
Yes, I've been sitting there. That's my guess.
So you testified that lines 78 through 83 permit 100% recovery, but I read it to be a 200% recovery. Is that your review of the committee? That was their intent, was 100% additional award?
I believe I would agree with you that there is some confusion there between between a 2 times or a 100% increase. Either increase would be a significant increase for employers to wear.
And then, that's all I have. So thank you, Mr. Chairman.
Further, Representative Osborne.
Thank you, Mr. Chair. Good afternoon, Mr. Myers. Thank you for being here today and providing us your perspective on the impact on businesses and small businesses in particular. With respect to the section regarding participation with the vocational rehabilitation counselor, as I read the drafting of the bill, lines 78 through 83, I'm seeing that those additional awards can be applied or be granted if a claimant has applied to participate in an established vocational rehabilitation program and they've met with the vocational rehabilitation counselor. I don't see anything there that requires them to follow through with it or to attend further vocational rehabilitation training that might be more likely to result in new employment or retrained employment. Would your objections be somewhat ameliorated if this section required actual participation for any length of time or a graduation, if there is such a thing, or a certificate of rehabilitation?
Yeah, thank you
I
very
don't know
much.
if that's a thing.
Thank you very much for your question. It's certainly something that we would certainly discuss it in terms of how it would work. Just be in mind there that the increase in benefits would mean an increased cost to employers there. But I agree that the current criteria of just meeting with them and just applying for the program is a minimal requirement.
So I don't pretend to be a workers' comp attorney either, but wouldn't it actually, in the long run, if somebody were to go through a vocational rehabilitation program and become rehabilitated and have alternate employment as a result in that, wouldn't that also favorably impact the employer's workers' comp rate because they would be reemployed and thus not paying out as long?
Sure. Yeah. As we said, it's a laudable goal to encourage injured workers to utilize vocational rehab programs. And we would be happy to work with the committee on finding ways to increase utilization of vocational rehab programs. Just bear in mind that we are concerned of this current proposal being costly to employers.
I thank you very much for your input. And thank you, Mr. Chair.
Further? Seeing none, thanks very much.
Thank you very much.
Susan Zabohansky. Susan Zabohansky with us? No? Okay. Leslie Wolfgang.
Thank you. My name is Leslie Wolfgang, and I am the Director of Public Policy for the Family Institute of Connecticut. I am testifying against SB 214. I'm providing some background on the bill, proposing an edit, and also addressing gender-affirming healthcare for minors more generally. In the matter of SB 214, the underlying law was likely passed in response to bans in other states of certain gender-affirming care for minors. The law creates hurdles for litigants before the state may use its resources to issue summons, subpoenas, and more. The state's ability to assist depends on whether there is gender-affirming care and a similar claim which would exist under the laws of this state. It is bound to raise suspect class issues and deserves closer scrutiny by people familiar with U.S. constitutional jurisprudence. At the root of every lawsuit is a hurting person In the matter of these lawsuits from out of state related to gender affirming healthcare services, there is likely a person who received gender affirming services as a child and is now suing a medical provider. The law creates another level of review and mechanism for a countersuit against people who are likely already experiencing mental, physical, and financial anguish in pursuit of their claims. Who makes the determination about whether there would be a similar claim under Connecticut law? How will it be proven? Minors in particular have no control over the laws of their state, whether something is banned or permitted. They have no control over the state where they receive treatment. This law creates uncertainties and hurdles for them as they seek to have their legal claims fairly heard and investigated. I recommend this bill be amended to exclude claims from people who receive their treatment as minors. States that have banned gender-affirming care for minors have a point. Gender-affirming care is not new, but it isn't settled science either. In my written testimony, I am providing a link to a February 2nd, 2024 New York Times article entitled, "As kids, they thought they were trans. They no longer do." And also, gender-affirming care is dangerous. I know because I helped pioneer it. You will hear and have heard from other people testifying today about the dangers inherent in gender-affirming care and their broad and heartfelt concerns. Thank you for your time.
Questions or comments from the committee? Representative Trubisky.
Thank you, Mr. Chair. Thank you for coming in. What do you mean you helped pioneer gender affirming care?
Oh, I'm sorry. That was the title of an article I included in my written testimony.
Oh, okay. Gotcha. I had another question, but it's disappeared from my brain. Is it your feeling that, well, tell me about the change that you would like to see in this bill?
Certainly. So I've included it in my written testimony, but I suggest in the definition that's being adopted that you insert after the word gender dysphoria in patients over 18.
Okay. Now there was another witness before you at some point that talked about the how that lawsuit might take place, whether it was somebody suing a doctor in another state and trying to execute a judgment. What is your understanding of how this bill affects immunity of doctors who perform these types of things?
Yeah, great. Thank you. So it's basically a doctor protecting bill. It protects doctors against suits from out of state by people who have been affected by gender affirming healthcare services. So somebody comes to, wants to sue a doctor, the doctor's here in Connecticut, they need to use the legal resources of our judicial department to help issue summons, subpoenas, and such. State of Connecticut has a law right now that makes them go through another hurdle. So first they have to prove that they receive gender affirming healthcare services, but also that they have a similar law in their state. So that's why we want to amend this bill. And it's hard to know what type of lawsuits there would be. Attorneys are very creative. So no matter what, a doctor gets sued here in Connecticut, they're going to have these extra resources to use against these people filing suit and make them show that there's a similar law in their state.
Okay, so a similar law in their state.
It could be anything. Actually, I would recommend some kind of legal review be done, maybe by OLR, going through the laws of other states and how this might pop up. And also, I suppose one of the problems of the bill, of the law also, is it based on current similar law at the time of the incident? What if the law changes during the suit? Doctors are going to be able to use this existing Connecticut law to throw up all kinds of obstacles against these people who are trying to make a claim against them for the gender affirming services that they received.
Now, when you say a similar law, are you talking about a standard of care?
It could be anything. That's one of the questions, Representative. What do they mean by similar law? Did it have to do with the standard of care? Do they have to have the same standard of care in North Dakota that they have in Connecticut? Do they have to have similar laws with regard to what care is prohibited versus what is permitted? Maybe similar laws with regard to malpractice. The law is vague around that area. So you have attorneys who want to represent these people in other states. Like they've been injured, they have a claim. But first before they can file a lawsuit in Connecticut against a doctor or use our legal resources to have a summons or subpoena issued, first they have to look at North Dakota law and Connecticut law and see if the laws were similar. I don't know a lot of other, I haven't really analyzed all the Connecticut law with regard to this, and I don't practice in this area, but why are we throwing up extra obstacles against people who, because they received gender affirming care? What the law does is it's protecting doctors instead of helping people who have been injured to come to this state and just use the resources that are available to everybody else when they need a subpoena enforced or they need a summons enforced. Not only that, the law creates the ability for a doctor to countersue against these plaintiffs and to recover their legal expenses. So let's say a doctor is sued, no matter what the outcome is, they can then turn around and sue that person in another state for the doctor's expenses related to that suit. That puts, you can understand this puts a chill on people being able to sue in Connecticut because attorneys don't want to have that liability. People don't want to have that liability of ending up being countersued by a doctor in Connecticut for simply pursuing your rights to file a lawsuit. That's where I see the problems in the current law, and I would hope that while we are addressing this definition in this committee, that we can tweak it and make it better for the people I think that we're really trying to help in the state.
Well, thank you very much for coming in. Thank you for your testimony. Thank you,
you.
Mr. Chairman.
Representative Day online.
Thank you very much, Mr. Chair, and thank you for your written testimony and your oral testimony here today. I've gone through it, and I appreciate you submitting that, and I may reach out. Thank you very much. Thank you, Mr. Chair.
Further questions or comments? Seeing none, thanks for being with us. Ann Manuski.
Good afternoon. I am testifying in opposition of SB 214. Chairman Winfield, Vice Chairman Flexer, Representatives Kissel, Afstrom, Fishbein, and members of the Judiciary Committee. I'm president of the Connecticut Republican Assembly, which is an organization which has members and friends totaling almost 600 Republicans and conservatives across the state of Connecticut. We stand firm in our principles and our unalienable rights under the U.S. Constitution, as well as the rights and responsibilities under the Connecticut Constitution. As I said, I'm Ann Manuski. I'm a 25-year resident of Connecticut, former licensed professional counselor who worked in Texas schools outside of Houston, and current president. In the Bible, it says God made man and woman in Genesis 1:27. Gender ideology comes from man. Dr. John Money, Dr. Kinsey, and other psychological and medical experts experimented on individuals, which we now see as gender ideology history. Dr. Money's first noted attempt was in the 1960s, done as a benevolent operation on a child who he fixed a botched circumcision. It was considered gender reassignment surgery. Many people since then have been part of the American Psychiatric Association's DSM Bible, which is people believe in science. And they've had torturous operations in attempt to transition from one sex to another. You cannot change your sex. Dr. Miriam Grossman, who I had hoped would be testifying today, wrote this marvelous book on Lost in Translation. Anyone who is concerned with what's being provided today should read this, because reproductive health care services and gender affirming health care services do not belong together. Reproductive health is one thing. Gender affirming health care is largely castrating our children. The Finnish psychologist who attorney Leslie Wolfgang mentioned, who was treating individuals, woke up to the fact that she was damaging individuals and is now standing up against the ruse of gender affirming care. This bill is another incremental change to the statutes to further gender ideological experimentation, providing counseling to those who are reportedly gender confused, creating gender affirming healthcare services into the statutes. That's a repeat, sorry. Minors being taught in our Connecticut public schools that gender is fluid is really troubling. They are being counseled in the schools, and they are being groomed to
Thank you, ma'am.
think that they are transitioning, that
Thank
they're
you.
allowed to transition.
Your time has expired. Thank you.
Excuse me, you're not even allowing.
Questions or comments from the committee? Are there questions or comments? Seeing none, thanks. Oh, Representative Veach?
Seconds for her to at least summarize and close that out.
No, ma'am. At the beginning, we said, if you have a direct question for her, you can ask a direct question. Absolutely, but. Go ahead, Representative Veach. If you have a direct question, you can ask it.
Can you, is she still with us?
Yep. Turn your microphone on that.
I'm sorry, but I didn't catch the last sentence that you were trying to complete, ma'am. I think she's gone.
Ms. Manuski, if you're there, the question was, could you read back the last sentence you read?
Sorry, when I was silenced, when I was censored, I didn't realize that my microphone was turned off. That I think it was the part that this bill is another incremental change to the statutes to further gender ideological experimentation, providing counseling to those who are gender confused.
Okay.
Was that the sentence?
Yes.
Representative?
Thank you for finishing that up. I appreciate that.
Thank you.
Thank you, Representative. Further questions or comments from the committee? Seeing none, thanks for being with us. Next up will be Aaron Everett.
Hi, I'm here to testify in opposition of SB 214. I was a trans kid. I was so insistent and persistent and consistent that I was a boy that my teacher referred me to a school psychologist for counseling. Thankfully, she did not affirm me. She did not tell me that my self-hatred was valid or that my desire to run away from myself was something to be celebrated. She did not suggest that I be put on puberty blockers to induce developmental delays or put me on a pathway towards dangerous cross-sex hormones and ultimately surgery. Instead, she put me in a special group of kids who needed extra support and came up with some simple suggestions for my teacher and my parents to help me with my difficult feelings. What the school psychologist didn't know at the time, because I was so filled with shame and confusion, was that I was insisting that I was a boy and believed that I was a boy because I thought it was the only way to stop me from being sexually assaulted again. In the summer between kindergarten and first grade, I was violently assaulted. And from that moment on, I blamed my girl body for the assault. I was sure that if I was a boy, it wouldn't happen again. It breaks my heart to imagine what my life would have been like if the school psychologist had told me I was inherently flawed and the only way to fix myself was to damage my body with puberty blockers, cross-sex hormones, and surgery. If I'd been encouraged to transition, I wouldn't have gotten the help I needed to understand that the trauma I endured and that I would not have understood that that I was convinced that my dissociating from my body was the only way that I could handle the difficult feelings of distress that I had about my body. Most of all, it would have prevented me from having the 3 beautiful children that I have that are a constant joy in my life. It is heartbreaking to me that vulnerable children with a history of trauma like mine, children who are autistic, children who have internalized homophobia, and children who don't adhere to aggressive sex-based stereotypes of how boys and girls are supposed to behave, are subjected to experimental interventions that damage their healthy bodies, especially when we know that the vast majority of them will resolve their feelings of dysphoria when they're allowed to naturally progress through puberty. When these children get inappropriate interventions from medical practitioners that damage them for life, they deserve legal redress for the harm. Please vote against SB 214 and protect the children of Connecticut from doctors, or protect children from Connecticut doctors, rather than shield the doctors from the medical abuse they're perpetrating. Thank you.
Thank you. Questions or comments from the committee? Seeing none, thanks for being on this.
Sorry, Mr. Chair.
Representative O'Day online again.
Thank you, Mr. Chair. Just briefly, Ms. Everett, thank you so much for your testimony and your bravery in coming here today and testifying before us. I've also read your online testimony, and I just want to say thank you. Very much appreciated. Thank you, Mr. Chair.
Thank you. Danielle Rhodes.
Hi there. My name is Danelle Rhodes, and I am the Director of Operations for the Foundation Against Intolerance and Racism. I'm also the Connecticut chapter leader, so I've been immersed in Connecticut civil rights for the past 3 years. Anyway, I'm testifying also in opposition of SB 214 as it stands today anyway. I just like to get, it's fortunate that Aaron was just before me, because this is the group that is specifically, I think, unwittingly being targeted with this particular language. And I think we can resolve that with very, very simple changes to the language in the bill. I don't know if you guys know this, but tomorrow in another state, there's going to be some legislation proposed regarding detransitioners' Bill of Rights. So I know there was commentary about the percentage of detransitioners earlier in testimony. And I just want to say that if there's being considered a Bill of Rights for this particular subset of the trans community, clearly there's a reason for that. There's a large percentage, and I do believe that 30% is probably smaller than what it really is. Anyhow, so I just thought I would make you aware that this is such a problem that we're now creating bills to address this issue. So I think Connecticut can very easily just modify the language here to expand, as others have proposed, the definition. If you just include all medical and psychiatric care related to the treatment of gender dysphoria, that should cover everything and everyone, including these detransitioners. And clearly an exclusion for children must be made here. I mean, it just seems, it doesn't, I don't know why we're not excluding children in this. They can't consent. I mean, that's part of the proposed legislation here, that you need to have informed consent. And obviously somebody that is not an adult cannot provide that consent. I mean, you can pick a number for the age of consent, and I know states are trying to lower that number in order to manipulate this, but I mean, I think we should be reasonable. So anyway, that's the proposal that I have is very similar to everybody else. But I also just wanted to make you aware that this Bill of Rights exists for detransitioners, and it's actually not our bill. It's another group that's proposing it, but certainly FAIR, that's the acronym that we use, is following this. And we're considering perhaps drafting legislation, and I would be happy to work with anybody that's interested in considering this. I think we need to
Thank you, ma'am.
Oh, sure. Yep.
Question for you, Representative O'Day.
Thank you very much, Mr. Chair, and thank you for your testimony. What state is that was doing the detransitioners Bill of Rights?
Tennessee will hear that tomorrow.
Okay. Well, I'll be happy to work with you on that. I appreciate you reaching out, and I've got your testimony think I
I
just saw.
didn't submit written testimony, but
Oh.
I will.
Could you please submit written testimony with contact info? Thank you. Thank you, Mr.
Absolutely.
Chair.
Thank you. Further questions or comments from the committee? Seeing none, sure we'll look for the Tennessee bill. Next up is Joseph Bentivegna. Joseph Bentivegna with us. How about Robert Priest? Robert Priest. Paul
Okay.
Knight.
Hi. Thank you, Senator Gary Winfield, Representative Stephen Staffstrom, and members of the Judiciary Committee. I oppose SB 214, and at the end, I address a specific part of that. You just mentioned information about D-Trans. I hope you would allow me to get you data from LGB Alliance and also an organization called GenSpec that focuses on that. I am an independent research and communications professional working in Northwest Europe. My parents and grandparents were born in central Connecticut, and I grew up there in a middle-class, blue-collar home. I attended high school as a gay teenager in the 80s, and I want to share my concerns about gay teens growing up in Connecticut today. I have been a proud lefty for most of my life, so rarely have I been critical of the left. But for the sake of gay kids, I am testifying. I and a growing number of gay and lesbians are very concerned about kids being told they are in the wrong body. I don't have to tell you that growing up as a gay teen in Connecticut was no fun. I did have a support network, and I grew to accept myself and my body. This is not what is happening with a number of gay teenagers today, especially the girls. A number are being told they were born in the wrong body, and for many teens who grew up in a difficult situation at home, this can be appealing, but this isn't a long-term solution. Many people like me believe it is the new conversion therapy, where gay teens are not accepted as who they really are, but convinced they are should be something else, the opposite sex. Some have had traumatic experiences. Some are just autistic. What these gay teens need are support networks, not puberty blockers, hormone therapies, a path to surgery, and a lifetime of medical visits. I feel very strongly that they are being used to make money, which is deeply alarming. LGB in several countries have had to form new organizations like LGB Alliance to represent our interests, because legacy organizations like ACLU and HRC no longer do. I've received death threats for my advocacy, but let me be clear. That is nothing in comparison to the idea of growing up in Connecticut today. That's terrifying. Please take a pause and listen to the evidence against gender-affirming care for children. Reconsider this rush. Ask why this is happening to push sex change operations on gay children and so quickly. At the very least, modify this bill to exclude lawsuits from people who were injured as minors. If they are brave enough to file a lawsuit and were harmed, good lefties must stand behind them 100%. I implore you to help them.
Thank you, sir. Questions from the committee? Representative Odega.
Thank you, Mr. Chair, and thank you, RJ, for your testimony here today. I saw your written testimony, and I will link to the articles or the links you gave us. And I can tell you, as a lifelong Republican, you and I are united on this issue.
Thank you, sir.
And I appreciate your testimony. Thank you, sir.
I will, if you can hear me, I will connect you to all of these opposition specialists. We have activists that have been pushing this, much in the way of a previous scandal, and I will connect you to them throughout Europe. And if I may say, there's one other element. You heard about Europe on how they're rolling it all back. The Dutch government has done exactly the same thing, and that's where the Dutch protocol came from. I can connect you to organizations that can provide you with solid evidence and the latest on this.
Please do, if you would. Thank you.
I will.
Thank you, Representative O'Day, and thank you, sir, for being with us. Erica Anderson will be next. Erica Anderson with us. Erica Anderson. Christopher Healy.
My apologies.
Okay, go ahead, Ms. Ames.
I am Dr. Erica Anderson, a clinical psychologist for 45 years. I have extensive experience in the field of transgender health, having served on the board of WPATH and as president of USPATH, the American affiliate. I have been a proponent of gender affirming care, having written the chapter on gender development in one of the seminal books on the subject. But the term gender affirming care has been hijacked. I also spent some years at the Child and Adolescent Gender Center at the University of California, San Francisco. Some activists are applauding the rise in the numbers of gender asserting kids, sexual minority and gender minority labels. But that's not the whole story. And my written testimony gives you a link to some surveys which raise some serious questions. Remember, I've been paying attention to these issues for many years. The rise in numbers coincide with many other issues, including the social isolation of young people during the pandemic, a rapid rise in the consumption of social media, as well as the advent of something called so-called social influencers. One example of which is the so-called TikTok ticks. I've been at this long enough to exercise some critical thinking as well as keep up on the science and my own experience. I'm a parent. I've seen thousands of patients over the years, and I am myself transgender. I'm collaborating with colleagues in Europe, including the United Kingdom. I speak with the primary authors of the systemic evidence reviews in Sweden, Finland, and the UK. And I've been in regular communication with Dr. Hilary Cass of the Cass Commission. I've been an expert witness in cases involving youth issues in the schools and clinics. I'm an advisor to several states, including trans health issues and several Canadian provinces as well. Unlike some, I do not think a legislative solution will fix the problems entirely, nor can a legislative correction fix the problems in other states. Have kids been harmed by overzealous providers trying to find trans kids and expedite their transition? Yes. Are there persistently transgender kids who need loving support, some of whom may benefit from medicines? In my opinion, yes. Are we now seeing fallout and the possibility of malpractice with kids who have changed their perspective on their trans status? Yes. I abhor simplistic solutions. Health authorities in Europe have pivoted away from routine applications of medicines. In Europe, they offer psychological support and evaluation, psychotherapy where needed for psychiatric care. They provide care consistent with the best guidelines and individualized comprehensive biopsychosocial.
Thank you, ma'am. Your time's elapsed. Questions from the committee? Representative O'Day.
Thank you very much for your testimony, Erica. I'm looking for it online and I don't see it. Could you just make sure that it's I may be missing it, but could you just make sure that it's up there? I would like to take a look.
Someone else offered to post it for me.
Okay. Just maybe reach out to them again because I can't find it. And if you get it to me, I'll get it to the chairs or ranking, but would like to see it. But thank you.
You're welcome.
Further questions or comments, Representative Dubinsky?
Thank you, Mr. Chair. Thank you for your testimony. So you're what kind of, are you a psychiatrist or psychologist?
I'm a clinical psychologist.
Okay, and in your practice, you have dealt with people who have gender dysphoria?
I have many times.
Okay, and what do you see as the problem with this bill?
So my understanding is you're trying to correct legislation that was passed a couple of years ago and take out the exception for gender.
Let's be clear, ma'am. The testimony was not correct. It was to consolidate and reframe the statutes. But go ahead, ma'am.
Well, maybe you can reframe your question.
Representative Dubinsky, do you have a follow-up question?
Yes. As you interpret this bill, what do you see as the problem with it?
My concern is that I think there does need to be a remedy for children who may have been harmed by overzealous provision of care.
Okay. Thank you. Thank you, Mr.
Further
Chair.
questions or comments on the bill? Further questions or comments? If not, thank you for being with us. Christopher Healy. Don't see him. Lisa Page.
Committee members, thank you for this opportunity to testify in favor of SB 272, an act. Thank you. Thank you for this opportunity to testify in favor of SB 272, an act concerning adoption of the Connecticut Uniform Trust Decanting Act. My name is Lisa Page, and I'm speaking as a trust and estates attorney practicing in and from Connecticut. As you heard at the beginning of today, since enactment of the Connecticut Uniform Trust Code, this state has strong and modern trust laws, but the lack of a decanting statute has left a hole that continues to limit the needs and the best interests that we can meet in full in this state. A trust is a relationship. The trustee holds trust property according to the terms of the trust for the benefit of the trust beneficiary. And a decanting is a transfer of trust property by the trustee from one trust to another trust, so that going forward, it's governed by the terms of the second trust. What I commonly see in my practice is a trustee coming to conclude that the terms of a trust are no longer serving the best interests of one or more beneficiaries. And in exploring solutions to that problem, looking to decant from the problematic trust into a new trust with terms that better serve the beneficiaries in that moment in time. Today, if that trust is in Connecticut, the trustee has limited options and none with the procedural safeguards or scope that would be provided by SB 272. Although it's true that sometimes trustees can find a route to decanting to meet the present needs under current Connecticut law, it's also true that the trustee can almost always migrate the trust out from Connecticut to another state with a fulsome decanting statute in order to decant under that statute. Increasingly in my practice, I see trustees electing to move a trust out of Connecticut in order to decant under statute. Existing Connecticut law on this subject consists of common law and one brief statute that is included in the written testimony provided by the Connecticut Bar Association. SB 272 improves on this immensely by reaching a much more comprehensive scope of trusts while also adding very significant procedural safeguards to protect the interests of all of the parties impacted. When I started practicing a decade and change ago, the question was whether decanting was permitted in Connecticut. I've watched my colleagues in the field become comfortable that decanting is or can be permitted in Connecticut, and in turn watched common law decanting become increasingly common in this state. In parallel, decanting statutes have also become increasingly common in other states to the point that today, 3/4 of states have a decanting statute.
Great, thank you. Representative Schmidt.
Thank you, Mr. Chairman. Thank you for coming here today. So currently, without this statute or these series of statutes, decanting in Connecticut is effectuated through common law, correct?
There is a common law principle under which a trustee can, under certain circumstances, make a distribution from one trust into another trust.
And then those, at least presently, do not go through the probate court, or sometimes they do. I think we heard earlier today.
So yes, as you heard earlier today, depending, for example, if the trust is under a will, trusts under a will are always subject to court oversight, and consequently, were there to be a decanting of a trust under a will, that would require involvement of the probate court.
So what, being somebody that practices in this area, what's the benefit for, like, let's just say New York,
Mhm.
and I don't know if New York has a provision.
It does have a decanting statute. It's had a decanting statute since
So
the early 90s.
It allows a Connecticut resident to take a trust that everybody lives in Connecticut and bring it to New York to have this decanting happen. Is that fair?
Sure.
Okay.
Yes, I think that's a way of describing it. A trust is governed by the law of
Great.
the state under which it was created. So you would have to migrate the trust to New York and elect New York law.
Okay, so how does, in your experience, how does New York get jurisdiction over those individuals, that trust? If nobody lives in Connecticut, the trust is.
There would have to be some connection to New York. It's not enough. That's, for example, the trustee might, you would have to turn to the terms of the governing document, the terms of the trust of itself, find some route to nexus in New York, for example, appointing a New York trustee and migrating trust operations to a New York situs.
And under the language that's before us for consideration, would it permit somebody who has, let's just say Vermont doesn't have a decanting statute, and to come to Connecticut with that trust?
This particular statute doesn't address trust migration. There are other principles under the law that would allow a Vermont trust to be migrated into Connecticut. If that Vermont trust were migrated into Connecticut, for example, let's say a Connecticut trust company was appointed as the trustee of that trust, and the trust were migrated to Connecticut, then that would be a Connecticut trust that would have the benefits of this particular decanting statute going forward.
And would there be a benefit to the Connecticut? Well, I mean, the probate courts are fee driven. They have to collect fees in order to, do their operations. Would that be a benefit to our probate court operations in Connecticut?
The particular scenario would depend on whether that migration or that decanting required court oversight, but it would certainly be a benefit to the Connecticut Trust Company that had this new business coming in from Vermont, for example. So the extent to which any one instance of decanting is a benefit to the probate court system depends on whether or not it requires court oversight. For example, whether it's a testamentary trust or whether there was some friction and one of the beneficiaries petitioned the court for involvement. So any instance of decanting has the potential to come before a probate court, but it's not necessary other than in some limited circumstances.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments of this witness? Seeing none, thanks for being with us. Christopher Arnold. Go ahead, sir.
Thank you, Mr. Chairman. Can you hear me?
Yep, go ahead.
Outstanding. Honorable committee members, the Department of Defense is grateful for the opportunity to provide comment on the policies reflected in raised Bill 5258, which provide a legislative vehicle to support the department's efforts in addressing interpersonal violence. My name is Christopher Arnold. I'm the Mid-Atlantic Region Liaison at the United States Department of Defense State Liaison Office. I'm here today on behalf of my colleague, Melissa Willett, your New England Region Liaison, who is on maternity leave. While DoD has led the implementation of enterprise-wide guidance on prevention, states are addressing harmful behaviors such as sexual assault and domestic violence by expanding protections for victims. Legislation such as House Bill 5258 can supplement these federal program efforts and changes. As I'm here as a pinch hitter with the understanding that there may be a substitute on order and there is similar language before the Veterans and Military Affairs Committee, I will speak generally toward how states have implemented policies that specifically address the issues of interpersonal violence by extending the legal authority of military commanders and military protective orders beyond military locations and duty times. Commanders can issue orders for military members in their command to have no contact with other protected individuals for safety purposes. However, these orders afford only limited due process and are only enforceable as violations of the lawful command order under command authority. Military protection orders are entered into the National Crime Information Center database and are viewable, but not enforceable by civilian law enforcement when they respond to an alleged incident. While these are lawful command orders, they are not recognized in state courts, and complainants in domestic abuse cases must obtain a civil protection order for civilian police to have authority to enforce a violation. The Connecticut general statutes do define a foreign order of protection to include any protection order issued by a court of another state as defined in 18 U.S.C. section 2266. And under this section, a protection order includes orders issued by a civil or criminal court to prevent violent or threatening acts, harassment, sexual violence, and related actions. While military protective orders may serve similar purposes, they are issued by military authorities, not civil or criminal courts. The committee should contemplate allowing military legal authorities to file military protection orders and a process by which to give those filing the order the opportunity to obtain a civilian protection order. Other states have facilitated a victim obtaining a civil protection order when an MPO is in place by requiring civilian law enforcement to notify military law enforcement or command when they respond to a violation, and closing any gaps in the MPO authority for National Guard and Reserve members who are not in active status by allowing victims to apply for a reciprocal state order with due process. States are also actively contemplating measures to ensure it is the duty of any law enforcement officer to ascertain whether an MPO registered in the database has been issued against any person subject to arrest who is a member of the armed forces. Law enforcement can then notify the commanding officer who issued the order with jurisdiction over the service member that there is probable cause to believe a violation of the MPO has occurred. In 2021, the Secretary of Defense ordered the Independent Review Commission on Sexual Assault in the Military to take bold action to address sexual assault and harassment in the force. The National Guard Bureau subsequently launched its own task force to look at sexual assault and suicide within the service. Since that time, numerous states have began without duplicating effort, supplementing.
Sir, I apologize. That's your time. I think may have a question for you.
Roger that.
Representative Conley.
Thank you, Chairman Staffman. It's good to see you again, Chris. I know you left us to go down to a different district, but like we say in Groton, it doesn't depend where you're going. It's how long till you make it back to Connecticut to military service. So welcome back. With this bill, I appreciate the work the DoD has done with the delegation in order to introduce this in a variety of bills that would help military members and their families. Could you briefly summarize how this bill would assist military members and their families who are dealing with domestic violence?
Thank you, Representative Conley. And yes, my new region is New York on down to Virginia, but as a combat veteran of a Connecticut unit, it's always great to be back in the Nutmeg State. I'd like to highlight that the issuance of MPOs, while distinct from civilian orders in procedural aspects, are driven by the core objective shared by all protective orders, the safety and well-being of individuals facing serious threats. And the department perceives, rather than viewing this as a question of equivalency between military and civilian orders, we should see it as an opportunity for collaboration and support. It's a solution that we can carefully craft to align with the federal guidelines while respecting the way things are done in Connecticut. And we have the opportunity to offer comprehensive protection to all residents, military and non-military, in House Bill 5258. Without diminishing the rights or protections of any individual.
Thank you. It's a good bill, and I hope my colleagues support it.
Thank you. Representative Howard. Oh, wait. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, sir. What precludes a one who has a military order of protection from filing a petition here in our Connecticut courts, bringing that to the attention of the court and going through our state process?
Copy. And that's sort of a complicated answer in as much as there may be folks serving on Title 10 who are transferring into the state or transferring out of the state. There may be folks who are in a Title 32 capacity serving with the Guard or Reserve who are called to an active status, and the offense may occur outside the state of Connecticut. And there's also the aspect of forcing victims to relive a potentially traumatic situation by having to provide, two sets of testimony, two sets of supporting documentation. So Maine, for example, streamlined both the military and the civilian protection orders to recognize the authority of commanders outside of duty times. Previously, the commanders could only issue orders for members in their command to have no contact with other service members, but those orders are only enforceable when they're on military status or on military property. And while those are lawful orders, they're not recognized in the state courts. So because of that gap, there haven't been consequences for harassment once the military training is over and the service member is off duty or off drill or off the installation where they spend most of their time. So the language found in Section 3 of the bill raised in front of the Veterans and Military Affairs Committee speaks to that aspect of it. But there are other instances which the bill before you seeks to address, crafted after the Illinois approach, and giving the military authorities the ability to file the orders, with the courts and under state law to issue some type of reciprocal civilian order.
I appreciate that. The question was, and I don't know if I got an answer, what precludes the individual from filing in our Connecticut courts, making part of their affidavit the fact that they have a military order and going through our state procedure? Is there something that precludes that?
Copy. No, nothing precludes that, and that is what folks will often do. So, the temporary nature of the military order, they may apply to the state court for a permanent order of protection or something of that nature.
Okay, so a military order of protection, who enforces that?
So the military law enforcement would enforce it, and the individual would be subject to the Uniform Code of Military Justice when a violation occurs.
Okay, so they are subject to a military set of laws. So now you have this military order, and a municipal police force is going to be called upon, let's say, to investigate a violation and then potentially arrest the individual, which would go to state court, not military court, correct?
Copy, yes. And there's sort of a little bit of complexity there in terms of the jurisdiction where the offense takes place. So for example, at the sub-base in Groton, there's areas that are in exclusive federal legislative jurisdiction. And the General Assembly took action a couple of years ago to provide a vehicle for us to transfer our jurisdiction back to the state to facilitate that type of occurrence. But by and large, most of the population lives off of the installation and they're already subject to the civilian authorities. So is that something that the local law enforcement is necessarily aware of? Are they checking the database? I think, you need to get after the procedures. And then in terms of the enforceability, the MPO in terms of the military side is non-enforceable off the installation. So if there's a civilian offense that's occurring in contravention of the order, there's not necessarily going to be any repercussions under the UCMJ.
So now we are asking through our state criminal court system them to apply military law in our state criminal courts. Is that how this would work out?
Negative. No, it would still be the same misdemeanor offense for violating the other types of foreign protection orders, such as one that was issued in New York or Massachusetts.
Okay, and what is the, how does, let's just say somebody gets a military order of protection. What is the procedure to notify law enforcement? I mean, we have a very robust procedure here in Connecticut with regard to civil orders of protection, family violence orders of protection, and law enforcement, state law enforcement finding out that that order is in place. What is the procedure for a military order of protection to be communicated to law enforcement in Connecticut?
Roger. So Department of Defense Instruction 6400-06, which is our coordinated community response to domestic abuse involving military personnel and certain affiliated personnel, sets forth the procedures for both issuing a military protective order and then entering that protective order into the national database and making the required notifications to the relevant civilian authorities. So that's typically done by our family advocacy program, the FAP as it's known, and they have memoranda of understanding with the relevant state and local agencies which articulate the specifics.
So the existence of the order goes into NICIC, and then the, let's say the protected party calls law enforcement to say, I have this military order. They run the person and NICIC comes back with a military order of protection. Is that what you're saying?
It certainly can, yes, if the FAP is made aware of it, and we've previously passed legislation, I think going back to 2017 or 2019, that got after identifying the military affiliation of a victim or a suspect and the time at which the notification takes place.
Okay, I'm still trying to figure out why this is necessary if one can apply in our state courts anyway. But I thank you for coming here today, and thank you, Mr. Chairman.
Further questions or comments? If not, thanks for being with us, sir. And with that, that concludes our list, and our public hearing for today is hereby declared closed. We will see everybody on Wednesday.